Yes, please.
Lord, contempt matters, Lord. Three matters.
Sorry?
Contempt matters, Lord. 3 matters of 22.
Contempt, this is the assigned bench.
Assignment.
So give the memo.
Ah.
No difficulty.
What about our CMPL? Because
CMPL this bench.
This-
Give the memo.
I'll want TRPC matter for transfer of the CP case.
Give the memo. Fresh matters to be listed.
My lord, page 2, item 11.
Yes, after the memo, then you mention.
My lord.
Yes, page 2, item 11.
Page 2, item 11, my lord.
After notice matters,
Some other day, my lord.
no.
Because I have to file some documents.
You wait. You have to
Previous
don't seek precedence over other lawyers. Please, you have to wait. If you do not attend the court, request any of your friends. Without passing a order, I am not adjourning any matter, even fresh matters. Please appreciate that. I can't pull out file and start dictating your matter. Mr. Sahoo is there. I have to take up his matter. Please don't do that. If you are not attending the court, request any of your colleagues. No difficulty. So no, after notice matters, not when it reaches, it will be adjourned, no problem, but there has to be an order. Looking at the order sheet, it will be passed.
My problem is,
So your problem is that you want to file something, do not attend the court, seek adjournment. I am not going to be party to that. Please appreciate. If you do not attend the court, it is your choice. I can't compel you. Request any of your friends to mention on your behalf.
I'll go it.
So it's up to you. I don't. I mean, it's a. Yes.
Pardon, Billets. Item 14. Billets, after notice matter.
After notice matter,
Billets,
no
2000
preemptive adjournment in absence of the other side. Without order, you have to wait.
I am
till
not adjourning, Billets.
So please
Billets,
wait, sir.
in
If you are not
two
adjourning,
occasions-
please wait. Don't make submission on merits out of turn.
Like counter, not file, Billets.
Whatever, sir. 1 to 13 has to be taken up. They have to file counter. They may concede. It's up to them. But please don't make that. Develop that habit of every matter to be adjourned at the initial stage. Yes.
My lord, I pardon.
Sorry. Kindly speak to the microphone.
My lord, my item 4. Is in order.
You are not audible. Wait. Item 4. You wait.
No, what I beg.
You have to wait, sir. You have to wait. Don't no out of turn. 4 will reach. If you do not attend the court, you request any of your friends.
My submission is
Orders will be passed when item 4 reaches. You make your submissions, but please be patient till 4.
that I understand. My submission
Mr.
is
Panda, please be patient till 4 is called. Make your submissions, sir. Nobody is preventing you. If you do not attend, or you do not want to attend the court, it's up to you. No difficulty. Yes.
Item 32, I am for the petitioner.
For that is the purpose behind.
You will be marked absent. So order will be passed.
My
So no preference because Mr. Panda is appearing. So I will start dictating orders.
no.
out of turn.
That I do not.
So I also do not say that. So why you are insisting?
In item 32,
Yes.
I am for the petitioner and learned counsel for the opposite party is also present. Here, shortly I have received the counter,
So that order, you want to file rejoinder.
your lordship,
Which for the other side?
your lordship.
Mr. Rao? Yes. When do you want?
After vacation,
Give a date. Give a date.
okay.
Suggest a date. What a date then happen? Upon the do a date. Take a
Uh,
Yes, next.
interim order to continue.
Interim. But the order will be passed when the matter reaches. Item of 32. सुनो ना जी. Yes, next.
Obliged, your
Call the
lordship.
list.
vehicle list, item 1.
Yes, please.
Lordship, praying for time. Item number 1.
Fresh matter.
Yes, Lordship.
You are
I am appearing on behalf of Mr. Amit Prasad Bose, Lordship.
Yes. What's your name?
Sanjay Kumar Panigrahi, Lordship.
It's your chamber case, chamber brief.
Yes, Lordship.
Start reading. Mr. S.K. Panigrahi on behalf of A.P. Bose for the petitioner. State is a party. Have you served copy on state?
Yes.
Mr. Sanjeev Swai AG for the OP number 9. Learned counsel for the adjournment is sought for on behalf of the learned counsel for the petitioner. Appellate, petitioner, no, appellate. When do you want?
After vacation, you will.
Dates करो.
First.
As spread for list on 2/7 2025. Yes, next.
Item 2.
Yes, please. Item 2. Yes, please. You are Mr. Behra.
Yes, Santiranjan
Santiranjan Behra for the appellant, for the petitioner. Yes. Yes, what's the prayer?
Yes, sir. My prayer is page number 9 and point number 1, para 1. My request, humble request before this honorable court is, this is a writ of mandamus. Direction may be given to the opposite party.
Humanitarian mandamus is there. 226 power is there. Humanitarian mandamus.
No, I had said because, sir, it is pending since last 20 years.
There is non-disposal you are saying, or you are?
So my humble submission is that it's pending. This case is pending since last 20 years. This need to be
Which
sorted.
case? The writ petition is 2025. So it is not pending since 25 years.
No, sir. It is here, but in the district level, it has not been sorted out. So
No,
that,
it's not a question of sorting out something. If you are seeking mandamus of inaction,
yes.
so what is the inaction? Kindly, sir, kindly elaborate on that or submit on that. What is the inaction you are alleging?
Right.
On by the which authority? Because from your prayer, it is not clear.
Sir, my client had taken a loan from the Khadi board to the tune of 60,464 in 2 installments for establishment of a sweet shop.
Sir, are you challenging the Khadi board loan?
No.
I don't think this is the assigned bench of these kind of petitions.
My lord, I am not challenging the order.
Please straight away come to what you are challenging, how you are agreed.
Sir, my point is this case need to be solved. This is to be sorted out since it is pending.
Sir,
law.
mediation as far as 226 is concerned, solution mediation, that's not beyond the scope of. You initiate any proceeding before any authority, the authority is not acting, then there is allegation of inaction on part of the authority, provided you have a legal right. That is a summons substance. In a very, very oversimplified way, you can say it is mandamus. So please say that which authority is not acting to your request or any petition is pending. But if you have taken a loan and not repaid, that can't be a subject matter of resolution as far as 226 is concerned.
Sir, the
Either
law,
there is a statutory right or any other right, kindly refer to that.
I could understand what your lordship says. My point is, the court is this case, the money has been paid, interest has been paid, more than 110%. Now it has.
So challenge that. If you want, if you are agreed by any inaction or action, you are alleging that it is illegal.
Yeah.
You challenge that action of wherever you loan, if it is amenable to the jurisdiction, you challenge that. And this court doesn't have jurisdiction there. This court has a jurisdiction in OPDR matter, assignment in OPDR matter. If there is an order in the public demand recovery proceeding, so whether there is a final order, whether you have challenged that final order.
So this has already been handed over to the
OPDR proceeding. Proceeding cannot be handed over. Proceeding has to be before the authority. The OPDR court, OPDR authority shall proceed with the matter. And OPDR, I think OPDR, there is an appeal provision also. So what happened to that?
So that is with the certificate officer.
Fair enough. So certificate officer, so the order has been passed by the certificate officer?
No, it has not been passed. They're not sorting it out. They're not.
So kindly show to this court that it is not a question of mere discussion or allegation. You have to state on note and show to the court that it is pending from the order sheet. You can file the order sheet in OPDR proceeding.
Okay. I'll do it, Your Lordship. Kindly give me some time.
The learned counsel for the petitioner was specifically asked regarding the cause of action for approaching this court. He submits that a matter is pending since long. On being further asked, which matter is pending before which authority? The learned counsel seeks accommodation to obtain instruction. When do you want, sir?
Within 1 week. if it is
I'll
possible.
straight for list. One week for a date please. As you know, 5 तारीख 14 तारीख हबो list on 14 5 20 14 or 12 21.
Sir, both are acceptable, my lord.
No, it has to be
14th.
Today is the best date. I could have disposed of. After spending this much,
Ah.
you would have followed that. I have understood the case.
Yes.
So there is no difficulty in disposing of today. But
Then-
since you are seeking accommodation, it has to be your choice.
No, I'm not seeking any accommodation. Kindly
Then-
do it.
then-
Kindly
then-
dispose it off.
then-
I will be grateful. I will be grateful. There is no point in lingering it.
You have no merit in the case. As far as the prayer is not clear, no claim, no allegation. So no case is made out. It has to be dismissed.
Sir, dismiss କରନ୍ତୁନି ତାହେଲେ ମୋତେ 14th ପର୍ଯ୍ୟନ୍ତ allow କରନ୍ତୁ.
I mean, those things with your age and experience, I think you must get the hint. When I dictated the order, I recorded your submissions. So you must understand that. You have not made out a case. Every time the court doesn't assist it should not also. As list on 14/5/2025. As paid for list on 14/5/2025. You make out a case. This can't be converted to a proceeding where no law, no facts. It's the court's perception of the things. No, you have a right. You have to fight it out. No problem. I mean the petitioner. Yes, next.
Obliged.
Item 3.
Yes, item 3.
Item 3, my lords, state is the appellant.
Please.
In the last occasions, my lords are directed to take fresh notice to 2E and 2F, my lords.
Yes.
And my lords, there are two
Kindly
orders.
refer to the order which
My lords.
was
That's order dated 2/4/24, order number 18. My lords,
Oh.
we had been given
18 to 21/1.
order number 18,
2F, right? 2E and 2F. That is 18/12, order number 16.
and my lords, subsequent dates, my lords, 21.
That subsequent date, there is no order. It's the subsequent orders refer to that
Yes,
18/12
ma'am.
order.
I'm sorry, ma'am. I'm sorry.
No, it did not be.
My lords,
Actually, I have to be there. If I say everything yes, then that is a problem. There will be wrong recording of the order.
my
Please
lords,
look at otherwise you can look at the order in that paper list. Yes, please.
my lords, all I submit, my lords, we have sought for the exact address.
The learned Mr. Prabhu Prasad, additional standing counsel for the petitioner. Mr. N. Ponda for the respondent numbers 5 to 7.
I am appearing for 5A to H.
Mr. Mohanty, A.K. Mohanty for opposite parties 5A to H.
5A to my lord, G, my lord.
5A to E and F, you are also appearing.
5A to
Acha,
G, my
2E, acha, 5A to G.
G.
5A to G. देखले A.K. Mohanty तापर लिखिबे hybrid mode तापर लिखंतु the learned counsel for the appellant respondent लिखछन तो submits that in terms of the earlier order dated 18/12/2024 reiterated in subsequent orders, the appellants have not been able to get the address.
My lords, yes, my lords, address, my lords.
Address of the newly added respondents to E and to F,
Yes, my lords.
substituting the deceased.
Yes. My lords, Millu Sahoo.
2 Sithile.
2.
Substituting respondent number 2 is deceased.
Yes.
Correct. The learned counsel seeks accommodation. After vacation, na kaun kari pari?
Yes, my lords. We will file it with
Accommodation till after vacation. List on 3/7/25.
I'm obliged.
It is expected that the learned counsel, the appellants shall do well to furnish the address and file the requisites.
Yes, my lord, we'll file.
Yes, next.
Item 4.
My lord, what I beg to submit, my lord.
Yes, please. Kindly speak to the microphone.
My lord, before I begin my submission, I may, with permission, seek to say that it is a matter relating to
whether the intervention could be
Are
allowed
you
or-
aware of the order dated 26, order number 26, this case 139?
No, what I beg to preliminary may say that I filed a note of submission along.
No, sir, don't confine. In an appeal, note of submission is irrelevant.
সেটা ମୁଁ ସେ କଥାରେ କହୁନି ମୁଁ ଯାହା କହୁଛି
So you are static. So kindly listen to the court also.
ରେକର୍ଡରେ ନାହିଁ ଏ କଥାରେ ମୁଁ କହୁଛି
No, it doesn't
ଶହେ-
matter. ଆପଣ ଆଗ ପ୍ଲିଡିଂ ସାରନ୍ତୁ ତାପରେ notes of submission ଖୋଜିବେ ଆପଣ ଚାମ୍ବରରୁ ଆଣିଥିଲେ ଆଣିକି ଦେବେ. I don't require any notes of submission.
Ma.
As a court, I have to go through the pleadings or not? I'll go through the notes of submission only.
ମାଇଲ
So kindly leave him this. You use the other microphone. Or you
ୟା ଉପରେ
so, ଅସୁବିଧା
ଅସୁବିଧା
ହଉନି
ଫାଇଲଟା
ଏ ତାର ଗୋଟେ ଟ୍ରେ ଭଳିଆ ଡ୍ରୟାର ଅଛି ତାକୁ ଟାଣି ଦିଅନ୍ତୁ. Then keep it there.
ଫାଇଲଟା ୟା ଉପରେ ରଖିବନି
ଆଚ୍ଛା ତାହେଲେ ଏଇଟା ୟୁଜ କରିବେ.
ନା ନା ଏଠି ଫାଇଲଟା ରଖିଲେ ତ କହିବ
ତିନିଟା ତ ଲଗା ହେଇଗଲାଣି ତଥାପି ଜାଗା ହଉନି. Yes, yes.
My lord, the claimants are the appellant here before my lord.
No, are you prepared in the case when looking at the last order?
Last order dated 2/4/25. My lord,
21-4. Every time the court will assist you with the order number, order date. You have not seen the brief.
no, I've seen
Then kindly look at the order, read the order.
order number. I
Order
can't
number
say.
26 dated 21/4/2025. Are you appearing in this land acquisition appeal number 33?
Yes, my lord.
So kindly look at the order. What jai se but order ta kadi dene se podi parenge.
Yes, my lord. Last time my lord passed that order.
No, read that order. You are pretending you do not know anything. Now you are saying that last time my lord has passed the order. You are saying order dated 2/4. Sir, this becomes a struggle actually. If you do not refer to order, I will keep on asking. So read that order.
The matter has been
21/4.
listed for orders. IA has been filed for intervention of the intending intervener petitioner stating at paragraph 2 and 3 of the following. Para 2, that it transfers from the impugned award that no notice was issued to either the East Coast Railway on whose behalf the land was acquired or the intervener company who has undertaken the liability to pay the compensation amount in respect of land acquired for the project by virtue of an agreement or MOU with the Ministry of Railways. It is submitted that in absence of the statutory notice as aforesaid, the award has always been held as a nullity. That due to want of notice, the intervener company did not have any opportunity to adduce evidence before the court, and that the compensation amount has been enhanced by the court at the instance of the appellant alone. There has been a clear-cut violation of the principles of natural justice. Intervener company is likely to be saddled with the liability to pay the compensation amount at a higher rate without any opportunity of hearing. Therefore, the impugned award cannot be allowed to stand. Para 2. Lord Counsel for the appellant submits that the appellant opposite parties have filed objection to the petition for intervention. Lord Counsel for the appellant, on being asked whether the appellants have stated in the objection that the intending intervener is neither a necessary nor a proper party for adjudication of the matter, submits that in absence of his Lord Senior, the matter may be adjourned. Now, my lord, in my to last paragraph. Perusal of the objection filed by the land use appellant does not show any response to the specific averment made in paragraph 2 and 3 of the petition as indicated above. That I am showing that yes, it is indicated there in the objection. That is, last time my associate could not press it, but in paragraph 2 of my objection, kindly have a reference to the paragraph 2 of my objection. I have replied to that.
Objection को flag रहे अच्छे.
In paragraph 2 minute I have said.
को flag रहे sir.
Sir,
Who
flag
pays
B, flag B. Objection to the intervention. Paragraph 1 starts from that the intervenor petitioner.
Just give me a moment. Give me a moment.
My lord, got it?
Give me some time. You have to get also something else. Are you aware of the decision of the Supreme Court?
Yes,
1995 1 SEC 221.
Yes, my lord.
Ah.
And that,
So also that is reiterated in
All-
subsequent decisions.
my lord, I'm highly
So kindly
obliged, my lord.
so because I have already held, so I can differ from my earlier judgment. So I have already passed a judgment.
My lord, what I beg to submit, my
So,
lord,
so kindly show the objection. I will see that you have objected it. Flag B.
flag B,
Ah.
paragraph 2.
Hmm.
So if my lord will allow me to place the fact,
You are complete.
Of course.
You are being allowed. Don't pretend that you are not being allowed. I am asking you. You are not responding. So which paragraph you have stated that the intending interveners are not neither necessary nor proper parties?
paragraph 2, my lord.
So
start.
kindly show that. Read that. You have to read that. For you, I cannot read. You read it.
My lord, I'm
Kindly read, sir.
Yes, my lord. That the miscase is not tenable in the eyes of law and fact, as the intervener is neither a necessary nor a proper party. The land in question was acquired for the East Coast Railway on acquisition for public purpose under Section 4, Subsection 1 of LA Act 1894. The land in question was never acquired for company ASR Limited, for which the intervener never appeared in court below.
So look at now the judgment. You have read paragraph 2.
My lord.
You say that it is acquired for the railways.
Yes, my lord.
Kindly read the judgment. Judgment impugned.
May I place the next paragraph so
Sir,
that
you will place, but kindly read the judgment. Then you will understand what you are placing. Please read the judgment that is impugned. Are you aware of the judgment, LA?
yes, my lord.
Kindly read that. You find the page?
My lord, for that also LCR has come up.
Yes,
What I beg to
sir,
submit,
sir,
can
you-
allow me?
Sir, I also beg you to look at the judgment.
My lord.
Because if you don't look at the judgment, then how the court will adjudicate?
Judgment para 1,
No, kindly read the cost title.
cost title.
Hmm.
Yes, my lord.
Find out where East Coast Railway is a party.
That I am showing, that is
Sir,
why
kindly read the cost title. Sir, you please place the
Yes,
cost
sir.
title. One
is Ramesh Chandra Patra,
Huh.
2 is Sarveswar Patra.
So
the
you don't
appellants
find,
here.
so they can't be the in the referral court. Railway is not the referring the matter. So who are the opposite party?
Opposite party is the special LO, Onugul Dubri Sukindar New Busy.
Stop there. So now kindly see the first paragraph.
ଟିକେ ମତେ allow କରିବ ଯଦି
ଆପଣ
ଗୋଟେ
ଟିକେ ମତେ allow କରିବେ ଟିକେ ମୁଁ ଫ୍ୟାକ୍ଟ ପ୍ଲେସ୍ କରିବା ପାଇଁ ଆପଣଙ୍କୁ I'll beseech you. Kindly read the first paragraph.
ଆଜ୍ଞା. This is a reference under section 18 of the London Land Acquisition Act made by the special LO, Onugul Dubri Sukindar Road, New
So
Busy
stop there.
project.
So kindly stop there. Neither so the officer referring the matter is made the opposite party. So from the cost title, neither the railway, because you say para 2 you have said railway, it is acquired for railway. You have placed, that's your contention. That's it.
ଟିକେ ମୁଁ ଆଉ ନା ଟିକେ କହିବାର ଅଛି ମତେ ଟିକେ allow କରନ୍ତୁ.
ଟିକେ ଆପଣ ଶୁଣନ୍ତୁ ଆପଣ ଟିକେ be patient with the court. You can't dictate. ଆପଣ ଯଦି ଗୋଟେ dictation ଦେବେ ଆପଣ steno ଆଣିବେ.
Dictation
So
ଦଉନି.
please wait, sir.
ମୁଁ କଣଟା କହିବାକୁ ଚାହୁଁଛି
ଆପଣ ଯଦି କହିବେ I will record it, but allow me some time, sir. Please
East Coast
allow.
Railway was noticed. That is my submission.
Please allow, sir. Please allow that to record whatever you have submitted. ଆପଣ ଯଦି ଏମିତି interrupt କରିବେ
ମୁଁ
proceeding,
ନାଇଁ ମୁଁ ସେଇଟା କହୁନି.
please wait, sir.
My lord, what?
Sir, why you are going on a continuous speech when I am requesting you that I will give you a chance? Please wait, sir.
Obliged.
I am also deeply obliged that you are allowing the court to dictate a order. I'm really obliged.
ହାର୍କିଂ ହେଇଯାଉଛି ମୁଁ କୋଉଟା କହିବାକୁ ଚାହୁଁଥିଲି
ନାଇଁ ଆପଣ ଯୋଉଟା କହିବାକୁ ଚାହୁଁଛନ୍ତି ସେଟା ଆପଣ ମାନେ ଜବରଦସ୍ତି ତ କୋର୍ଟ ସାଙ୍ଗରେ କରିବେନି.
ନା ନା
So please don't do ଜବରଦସ୍ତି.
ମାନେ I seek permission only.
Sir, I also seek permission to dictate a order. You please wait, you make your submissions. The Mr. Niranjan Panda for the Learned Council, Mr. Panda, Mr. Niranjan Panda, Niranjan Panda appears on behalf of the petitioner in response to the order dated 21/4/2025, passed in Miss Case number 139 of 2016. He makes his submissions. The said order dated 21/4/2025 is reproduced herein. In response to paragraphs 3 and 4 of the order as indicated above, he submits that in the objection dated 30th of September 2022, filed on behalf of the filed by the appellants through the appellant number 3. Paragraph 2 is the answer to the said observations. The paragraph 2 is quoted here. Paragraph 2 ta quote kar that the miscase is not tenable, flag B re achi.
Paragraph 10.
The paragraph 2 and 10.
Yeah.
Paragraph 2 and 10. Quote kar dele. 10 re achi.
10 टा पढ़िए यदि कहबे.
That the law is well settled, that only the beneficiary person is interested.
Only the beneficiary
Kindly,
person.
sir, kindly just allow me. Don't interrupt, sir. There is a difficulty when you speak in the microphone. He cannot listen to you. Sir, kindly just.
More proposal to bring this.
Please, sir, I am doing my thing, sir. Whenever you find anything erroneous, you have said 10, I have dictated 10. But you start speaking in the microphone. Please appreciate that. It's not a conversation between the court. It has to be a proceeding, has to be there. Please appreciate. Having gone through the paragraphs 2 and 10 of the objection, the Learned Counsel was again requested to go through the judgment in LA Miss Case number 126 of 2013, which is the challenge in the present proceeding, and the IA has been filed for seeking leave. The Learned Counsel fairly submits that East Coast Railway, as indicated in paragraph 2 or 10, has not been made added as a party in the petition. The authority, that is Special Land Acquisition Officer, Hon'Ble Duburi, Sukinda Road, New Broad Gauge Rail Link Project, has been made the party, opposite party. The judgment at the opening paragraph itself refers to the said opposite party, as indicated herein. First paragraph likhiye, quote, this is a reference under section 18 of the Land Acquisition Act made by the Special Land Acquisition Officer, Hon'Ble Duburi so and so, price of the acquired land. On perusal of the judgment, it is apparent that the Learned Court has not framed any issue regarding whether the requisitioning authority requesting the land acquisition or the special purpose vehicle that executed the project are made parties. or they are liable to pay any enhanced amount. The issue framed by the learned referral court is reproduced herein as contained at paragraph 5, contained in paragraph 5 of the judgment. 5. The point that needs for determination is whether the petitioners are entitled to have an amount of higher compensation than the amount settled by the opposite party. The issue also very candidly reflects that the opposite party only settled the amount without referring to the requisitioning authority, that is East Coast Railway, or the special purpose vehicle. Yes. Next. Yes,
Requisitioning authority has already paid the compensation amount that has
No,
been-
kindly make your submissions on this, because we are dealing with a IS seeking leave to
Yes,
appeal.
my lord. The requisitioning authority, that is the East Coast Railway, the decretal dues has already been paid. Now, the present appeal is for further enhancement of
It is submitted by the
dues.
learned counsel.
Now, with regard to the
for
intervenership, what I beg
for
to
the opposite party, that the decretal dues have been paid by the
East Coast Railway,
requisitioning East Coast Railway,
possession has been taken.
who are not parties in the referral. In the LA Miss case number 126 of 2013.
Now,
The reasons for an authority who is not a party to a referral under section 18 of the Land Acquisition Act satisfying the decree as stated is not indicated in the objection or in the judgment. The direction by the Civil Judge Senior Division was to the special LAO, Hon'Ble Duburi Supinda Road, New PG Rail Link project, to reassess the compensation. There is no direction as such to any of the authority for payment of such compensation. Yes, next.
man, what I beg to submit, my lord, initially at the time of reference, the notice was issued by the LAO. It was communicated by the LAO at the time of
By
sending
which
the
order?
reference that, my lord, kindly
which
refer
order?
to my paragraph 4
Sir, by which order? By
by
which order?
the reference letter itself. Kindly have a glance to the LCR has
By
come.
which order, sir? Don't show me finger and all these things. Kindly refer to the which order issued notice to which opposite party.
That's the
It is submitted.
my lord. By letter number 603, dated 13.
Sir, letter no, by which order? By which order? You see, the court doesn't send letters. Please appreciate.
When reference is sent to the court, that is a letter.
Sir, I am not asking that. You are saying that the referral court issued notice to so and so.
May I pray, my lord, to have a glance to that reference itself. The
Sir,
reference that
sir,
has been made.
the learned counsel for the opposite party submits that the referral court issued notice to.
The referring authority.
Referral court, sir.
No, I'm not.
Sir, the court the submits that the referring
the
referral
referring
court
authority,
issued
that is
notice.
special LAO, in his letter number.
କହିଲେ ମୁଁ ମନେ ରହିଲା ଆପଣ ଭାବୁଛନ୍ତି ମନେ ରହିଲା ଦେଖ ଟେଷ୍ଟ କରନ୍ତୁ ଟେଷ୍ଟ ବାଇ memory also. That means that the referral court issued notice to the East Coast Railway. କାହାକୁ notice issue କଲେ?
To the East Coast Railway
To the East Coast
and
Railway.
to others also.
On being asked by which order, the said notice was issued by the referral court, that is Civil Judge Senior Division Kamakya Nagar in LA number 126, LA Miss case number 126 of 2013. The learned counsel submits that the authority land acquisition authority, while referring the matter to the under section 18 of the Land Acquisition Act, by letter intimated the East Coast Railway. Such submission is contrary to the material on record,
No,
the
that is their
judgment,
material is there.
judgment as well as the reference does not indicate that the judgment on the face of it doesn't indicate that the requisitioning authority East Coast Railway was ever noticed, was ever made a party, much less ever noticed by the Learned Civil Judge Senior Division, Kamakhya Nagar, as is being suggested by the Learned Counsel for the the respondents. The opposite party in the LA case issued notice to another person, another authority, which is beyond the scope of law, when the special LO was himself the opposite party in the adjudication. He could not have issued notice to another person to appear or place their version in the proceeding. The judgment has also not dealt with that aspect, whether the land division of the land, the requisitioning authority or the special purpose vehicle formed for the purpose of the construction were ever made parties, much less issued notice to state their case before in the reference. Yes.
My lord, initially, my lord was, the coordinate bench was pleased to call for the LCR in order to see if the LO has issued notice or not. And LCR has come up, LCR is there. I may be permitted to place paragraph 4 of my note of submission.
No,
I have specifically
go
said-
by the records. Otherwise, I'll record that instead of referring to the records, you are only going for the submissions. Will it be palatable to you? I'll record that.
Just ma'am.
Sir, kindly confine to the records in appeal,
Yes,
because you see,
I'm confined to record.
fast. If a appellate court goes beyond the records, it will
No,
be
that's-
it is not vulnerable.
I beg to submit that it is in the record, my lord. I say that.
So you refer to the
I say that it is there in the LCR itself. That
Sir,
I beg to say.
Sir, I have been requesting you, please give me the date of the order. You are not answering. Your answer I have also recorded that the land acquisition authority.
May I be permitted to place paragraph 4 so that I will be satisfied that
Sir, don't.
I have placed the matter before the court.
Sir, let us finish from the records. The Learned Counsel for the petitioner for the opposite parties repeatedly wants to place
No, I'm not opposite. I'm the appellant.
You are the appellant here.
My lord, I'm the appellant. I have come up in the appeal. The claimant is the appeal.
So change kar de, claimant appeal kar de.
Claimant has come up for further enhancement of the awarded amount, because the awarded amount in other case that was decided.
Then your strategy should be get a remand to implement them as a party. I thought that you were objecting because of.
No, my lord, I am the appellant.
सब जगह रे जोड़ा नहीं कि respondent जोड़ा को appellant कर देंगे.
The claimant is the appellant before my lord.
Yes, thank you.
That was my first
kindly refer to the order where the notices were issued to the opposite party in the LCR. I am holding the LCR.
My lord, what I beg to submit, if my lord will allow me,
You are being allowed, sir. Everything is quoted and reflected. So by which order, though repeatedly asked,
that
the Learned Counsel is unable to answer on which date the land acquisition, the referral court, Civil Judge Senior Division issued notice to.
The Senior Division has not issued the notice.
Issued notice in the proceeding. That is LA Miss Case number 126 of 2013.
My submission is not that, my lord.
2013. Sir, that is my question, sir.
My question is,
sir, on being repeatedly asked in the proceeding as suggested by the Learned Counsel that the interveners, project proponents.
Intervenor question doesn't arise. with regard to this East Coast
Sir,
Railway,
kindly-
that I am pressing, my lord.
sir mate mu order ta dakuchi apan order ta I am not tale apan kindly wait sir, kindly wait apan ko mu samay douchi. Every time I start dictating, you interrupt. Please don't do that.
Sorry, my lord. If my lord will, sorry.
Kindly-
My lord may pass any order.
Kindly wait. No, I am not passing any order. That I will also record. I have the advantage that everything is now recorded.
My lord,
In a court where it is live and recorded, I have the advantage.
my lord.
This pretension that I am not allowed to speak, my lord may pass any order, it is also recorded. That's the advantage of it. Or let me- were noticed in the LA Miss case number 33 of 126 of 2013. The Lord Council submits that. Should I write that my lord may pass any order? The Learned Council doesn't want to answer that. He refers to his written note of submissions. That much.
Only
Yes.
I wanted to place paragraph.
Yes, you now you place, but I'm allowing you to place, but don't interrupt me when I'm dictating something. Please.
Sorry for
You
that.
place it.
No,
I'm very sorry
intentionally
that
not-
I'm very sorry, Mr. Ponda. Every time I start dictating, you interrupt. Please don't do that.
Sorry for.
So I'm very sorry. Please place you place whatever you want. But I can't go beyond the records. You must understand. That I have to tell you repeatedly.
Yes, my lord.
That in an appeal, I'll go beyond the records and start considering
fine.
whatever is there. Yes.
My lord, beyond record, I am not going. That is the award of LO.
Where you are reading, sir? Kindly refer where you are reading so that I will get it. कौन टा पढ़ुचंदी कुहंतु मु बाहर करबी तो फेरे
Paragraph 4.
कोथिरे paragraph 4
Mo note of submission, paragraph 4. Sithira I have highlighted everything. Note of submission, paragraph 4.
note of submission paragraph 4 आपण होचंती appellant
Much appellant. I have filed a note of submission for 132 pages. Now the record shows only 74 or 84 pages. The rest pages are not there, not uploaded. Even I checked up that is not also in the record.
आपण paragraph आपण
That is
paragraph
why I just beginning.
आपण केबे आपण फाइल कले
ମୁଁ 1/23
हां ठीक अछि paragraph 4
1/12/23
हां paragraph 4
1/23 कोर्ट रे हां paragraph 4 both the sides have filed the note of submission respectively.
sir kindly place sir आपण paragraph 4 yes paragraph 4
हां madam.
ଆପଣଙ୍କର ସେଟା ହେଉଛି flag 2 for your kind information and whenever you next refer to that refer to flag 2 कोड पाई परिवे
Fine.
लिखि दियନ୍ତୁ ସେଟା
Correct. That age award of LO was inadequate pursuant to deposit of money by East Coast Railway. The claimant sought for reference to court below. While sending reference to court, the special LO has intimated the same to the East Coast Railway for their needful, which is available in the LCR itself. The East Coast Railway, knowing well regarding the reference proceeding, has also accepted the enhanced award amount made by the reference court. The East Coast Railway also
Mr. Ponda, that is a submission against you or in favor of you?
in
You
favor
have to be you admit that it was not issued in para 4, that it was never, he was not made a party. East Coast Railway was not made a party nor issued notice. You admit that in para 4? Yes, please carry on.
The East Coast Railway also requested the special LO for payment of decretal dues by its letter dated 29/6/15, and accordingly the decretal dues was paid. When the requiring authority is very much concerned of acquisition of land, taking over possession
Requiring
of
or
land,
acquisitioning?
payment of compensation amount, etc., the intervenor company has no locus standi as per the law. The agreement between railway and the company would show the company in lieu of finance will enjoy entire revenue of project for a period of 30 years, and the Union of India will reimburse
Flag
the
2,
cost of
paragraph
acquisition
Flag
if
2,
remains shortfall. Thus, acquired property is neither vested to company nor the company is at all
ଟିକେ
in
ଗୋଟେ
picture.
ସାଉଣ୍ଡ ଟା କମେଇ ଦେଲେ ହବ ତାଙ୍କୁ କିଛି ଶୁଭୁନି yes flag 2 paragraph 2 flag 2 paragraph 4 yes next
Then paragraph 5.
para 5
In paragraph 5, shortcut କରି କହିଲେ ମୁଁ କହିଦେବି, ନଚେତ ପୁରାଟା ମାଇଣ୍ଡ କିଛି କହିବେ ପଡିବ।
ଆପଣ ପଢିଲା ବେଳେ ସରି ଆଉ ଥରେ କହିଲେ କଣ shortcut.
মানে
No, sir. This is not a rocket science. This is very simple. The appeal comes up for hearing. Whether the party, those who are necessary parties are there or not, that's the short question. With your vast knowledge and experience, I mean, in CPC and all this proceeding, is the simple point.
My only answer, my lord, whether it is a necessary party or prime.
Yes, exactly. So that was coincidentally that was framed as a question on the last occasion when the matter was urgent.
Last occasion, I was not there.
Correct. So in fact, I never went through your written notes to frame that question. So yes, para 5. Then next, sir.
It is relevant to submit here that ASR Limited has filed appeal against one Pitambar Sahoo in law number 47 of 2015. The miscase number 244 of 15 arising out of law was filed by the respondent claimant Pitambar Sahoo challenging the maintainability of the appeal. The miscase was disposed of in order dated 29/4/2016. By then, the decision of Supreme Court in reported in 2017 for SCC 760 and 2022 AIR online Gregory Patra versus Mangalore Refinery and Electrochemicals were not there. The Honorable Court mainly relying
Mr.
upon
Ponda,
the said order.
Mr. Ponda, may I interrupt you? Do you have those citations, copy of those citations, or I'll have to get it? Have you read those decisions? These two decisions, have you read? Volume को देले मोकता सुबुनी सुबुची दा मोकता
Audible helan.
there's some
Audible only.
can you please hear?
Yes, now.
So have you gone through those decisions, this 2017 4 SCC 760? Have you gone through this?
Yes, ma'am. Has
This is-
disposed
this
of
is on
some
that
other
point.
cases.
This is on that point. You have the citation with you. 2017 4 SCC 760. Do you have the citation with you?
Yes, okay.
Is it on that point?
That I have given. That is not there in the record. That I am
No,
saying.
I have that. I have that. So
Milord.
please carry on.
One more sentence. Finally, the said law 47 of 15 was disposed of as the decretal dues has been paid to the claimant. Thus, the order passed in a miscase finally ended after the final disposal of LA appeal with the aforesaid result. A copy of the final order in law 47 is made enclosure 1. That is there. That is there. Enclosure 1 at page. At
You are
page
referring
11.
You are referring to another LA.
Another LA.
LA, right?
Where the ASR Limited company has come up in appeal and it was opposed to with regard to the maintainability. Initially in the miscase, it was decided the yes, company may sue, and ultimately in the final result.
Mr. Ponda, maintainability, as I have understood the law, can be raised any time at any level, because that goes to the root of the matter.
The result that was the order that was passed in the miscase.
So
ultimately,
by throwing someone by saying that it is not maintainable, it doesn't help the court also. The court will be always asked this question, that whether it can be thrown at the stage of threshold, something is not maintainable, because you are just simply shutting the door.
Finally, the law was disposed of, saying that decretal dues has been paid. Once decretal dues has been paid, the miscase that with regard to any order ultimately merges with the final order.
The problem, Mr. Ponda, is that the decretal due has been paid by somebody, not a party. Has the learned court in the LA taken note of that?
My lord, what I beg to say, that the requisitioning authority has paid the amount. Now, company
The
who
requisition
has come up
the
in
requisitioning
appeal,
authority may think to pay any amount, anything. There is no provision in law for the requisitioning authority to pay amount. Suppose amount awarded is 100 rupees. The requisitioning authority pays the land house to 300 rupees. Is there any bar? There is no bar. So that is not a precedence. The question is a legal question. Somebody paying the amount when he is not a party, nor even suppose, let us assume X has paid, not a party. Y, who is a party, has contested, and the award is against Y. Then also there can be some semblance of logic bringing in contract act, which is also very difficult. That how X will satisfy Y's decree. The judgment debtor Y, how it can be satisfied by X? There may be agreement between X and Y.
my point
Kindly listen. If you want to listen, then I'll articulate. So that is the difficulty. So somebody paying somebody's decretal amount who is not a party. Now the problem is when Y is not a party, he wants hearing. So Y may pay more also. That is not being adjudicated. You must understand. So
I'm obliged.
So
The next point
that is not being discussed.
Madam,
So please read further. Any other paragraph you want to place?
I place the next point. The next point is an enclosure 2 I have filed. That is a order of division bench of this honorable court. That paragraph 6, I have written it. The company has also come up in a writ petition. This division bench has held it company has no locus standi. It cannot maintain. The honorable court in WPC number 14935 of 15 and miscase number 3636 of 16.
ଭଲ କଥା ମୁଁ ବି ଜାଣି ପାରନ୍ତି ଆପଣ ଯେତେବେଳେ ପଢୁଛନ୍ତି କୋଉ ପାରାଗ୍ରାଫଟା ପଢୁଛନ୍ତି ଯଦି ରେଫର କରନ୍ତି ମୁଁ ବି ଟିକେ ପଢି ପାରନ୍ତି
ଯୋଉଠି ପଢୁଥିଲି ତା ପରଟା ପାରାଟା ପାରା
କେତେ ସେଟା କେତେ
ପାରା 6
ଆଜ୍ଞା
ପାରା 6
ଆପଣ 10 କହିଲେ ତାପରେ 6 କୁ ପଳେଇଲେଣି
ନା ପାରା 5 ରେ ଥିଲି 5 6 କୁ ଆସିଲି ଏନକ୍ଲୋଜର 1 ରେ ଥିଲି ଫାଇନାଲ ଜଜମେଣ୍ଟ ଅଫ ପିତାମ୍ବର ସାହୁରେ ଥିଲି ଏନକ୍ଲୋଜର 1 ରେ
ବଟ୍ ଆପଣ ମତେ କାଇଣ୍ଡଲି ଗୋଟେ ଡିସିଜନ ଦେବେ କି ଯୋଉଥିରେ କି ଦ ପାର୍ଟି ନଟ୍ ଇନକ୍ଲୁଡେଡ has been allowed to
only my whole sentence one sentence will be he can be
Which
a party if he is
Mr.
necessary
Prasad,
or a
Mr.
proper
Prasad,
party.
which is the best decision by the High Court referring to Supreme Court decisions? Have you on this point there are a series of Supreme Court decisions. So have you gone through any one of the decisions?
Yes.
Which one?
22
2017 is not on that point. That's the
the
difficulty.
citation that is there it is said if it is not a proper party not necessary to be made a party. Now what I beg to submit that company cannot be a necessary party, cannot be a proper party. And that is in
I hope you are able to hear me. Mote apon mo katha subuchi ta apanku whether the project proponent or the requisitioning authority or the authority which is special purpose vehicle, like there are so many projects. He is a necessary party or proper party. There are several decisions of the Supreme Court.
I got the point, my lord. My lord is asking.
Have you gone through any decision?
Yes, my lord.
So which one favors you?
Satish Gupta decision.
Sorry?
2017 4 SCC 760. That is the point. And subsequently it is confirmed also by another decision. Gregory Patra.
I am not as quick as you are.
Air online.
I am not as quick as you are. I have to go through those. Look at that decision. Please give me some time. When you are citing a decision, I am not that quick that I will jump to that. You start reading that, reading 2017.
That is before my lord. My lord will be.
No, I have all decisions.
The
entire book set is with me, so that's no difficulty. But you please refer to 2017. Which part you want to place?
Yes, my lord. I have also quoted that.
2017. Just go through the
paragraph 8 टिके देखिए.
2017.
My lord.
2017 जो कहउचंती citation टा 174 SCC
Before
760.
But
So kindly look at that.
citation.
आज्ञा. 174 SCC देखंतु टिके.
आज्ञा देखो.
देखो.
The highlighted portion given in the Precedent that
Sir 2017 4 SCC page 760 which paragraph आपण पढुचंती?
paragraph 9 and 18. That my lord, I have, that is there before my lord. I have that given that decision is also before my lord.
That can it not be before yourself, your good self, apart from the decision?
Yes, I am
before
reading
my
it.
lord.
I'm
So
reading
kindly.
the summary. I am reading it, my lord.
So kindly refer to that paragraph where you are relying on.
ଟିକେ ପଢୁଛି. The ratio is decided by the Honorable Apex Court in Satish Kumar Gupta's case, reported in 2017 4 SCC
So kindly, which
760
paragraph?
held as follows. Held as follows.
That Satish Kumar Gupta, which paragraph you are relying on?
Paragraph
I don't want your annotation on Satish Kumar
paragraph
Gupta.
9 and 18 ବୋଲି ଲେଖା ହେଇଛି. ତଳେ ମୁଁ ଲେଖିଛି ସେଥିରେ.
କୋଉ paragraph ଟି କୁହନ୍ତୁ କହିଲେ ମୁଁ ବି ଟିକେ ଦେଖନ୍ତି ସେଟା.
Paragraph 9 ଓ 18. ପୁରା ପ୍ରାସିଟମଟା ମୁଁ ଉତାରି ଦେଇଛି ଯଦି
ଆପଣ ସେଟା ପଢି ନାହାନ୍ତି. With greatest of respect.
Paragraph
Satish
9
Kumar
and
Gupta you have
17.
not read.
ଆଜ୍ଞା. To determine paragraph 9 place.
Satish Kumar Gupta, there was acquisition. So can I now share with you, because I have read Satish Kumar Gupta, the facts?
Facts are similar almost.
Completely different. Question of
Facts
law is
are almost
completely
similar.
different. Completely different.
The principle is decided.
Completely different. In Satish Kumar Gupta, there is acquisition of land for Gurgaon.
And subsequently,
Somebody purchased that land. Whether that purchaser, subsequent purchaser or user will be a party. And in fact, Satish Kumar Gupta is against you to the extent that if it is the project proponent or the land acquisitioning authority, to that extent, they are parties. Because the land acquired is sold to so many subsequent purchasers. There may be 5, 6, 7, 8 purchasers. So kindly read Satish Kumar Gupta. Satish Kumar Gupta is against you.
question is whether part 7, if is complied with, the company is a necessary party.
Kindly read which paragraph of your Satish Kumar Gupta you are relying on.
Paragraph 9 of Satish Gupta
Paragraph
case.
9 of Satish Kumar Gupta.
Satish Gupta case para 9 ଟା ପଢୁଛି. To determine the question whether the post acquisition allotee.
Just give me a time. I'll go to paragraph 9. ଆପଣ ଯେତେ quick ଯାଉଛନ୍ତି ମୁଁ ଏତେ quick ନୁହଁ ଆଜ୍ଞା.
ସେଟା ପାଇଲେ କି para 9 ଟା.
ପାରା 9 ସେଇଠି ପଢନ୍ତୁ. ସେଠି ଆପଣଙ୍କର ଡାହାଣ ପଟେ ପାରା 9 ଅଛି ଦେଖ.
Para 9 page to me page is 77. That is there also in the in flag.
Paragraph 9 is, that is how I told you, sir. Satish Kumar Gupta, paragraph 9 is just
citation.
completely against you. पढ़ो para 9 पढ़ो. To determine the question.
To determine
authority acquiring land in Gurgaon, allotting land to somebody, so many people. Now there is enhancement of land. So you kindly mark this.
There the question was there.
So kindly
they pleaded that because they were financing, so that the question.
So post acquisition allotee.
Next. It is for my lord's kind perusal. 4.1 notification speaks only for not for the company, because purpose of acquisition either for public or company. Here it is for the public, purpose of public.
Kindly look at जो decision टा cite करचंती. You are citing a decision. Look at reference number 16. The judgment are, Mr. Das, can you assist Mr. Ponda? Just show him the serial number 16. The decision टा जोड़ा अपन धरचंती. The cases related अपन जोतरे अच्छे. Supreme Court जोड़ा decide कर ले. देखो तो fast page ले. I don't tell.
I am mainly relying upon two decisions.
नहीं.
Para 16.
Page 765 or 768. देखो.
My lord is referring to
Para 15 पढ़ंतु. Para 15 of sorry. Satish.
my
Para 15 देखें.
that is not distinguished. That is why I am saying.
ये पढ़ंतु.
My lord. Para 14. We are in
15 sir, 15.
in Himalayan tiles, the acquisition under Part 7 of the Act in Santosh Kumar, the question was whether award of the collector could be challenged, to which this court answered in the negative, except on the ground of fraud, corruption, and collusion. In Navy Lignite, again, the acquisition
Please
was
slowly,
under
please slowly,
Part
slowly.
7 of the Act. And in that context, this court held that the expression process could include a company or local authority for whose benefit the land was acquired. Yes, my lord, that is my point.
नहीं ठीक है ता परोटा पढ़ो.
My lord. The post-acquisition alloty cannot by any stretch of imagination be treated as on a par with beneficiary for whom the land was acquired
So stop
in
there, stop
UP
there.
Awas Vikram case.
So say that छोड़ो तो Navy Lignite Corporation.
My lord.
छोड़ो तो तापर आवड़ जिन
The matter dealt with
ठीक है Mr. Pandit. Please be responsive to the court. You don't. So Navy Lignite Corporation has neither been distinguished nor been overruled. So that is how, in fact, Satish Kumar Sharma reiterates Navy Lignite Corporation. So that is how Satish Kumar Sharma is not a decision favoring you. It is against you. Para 15 is very clear.
no, my lord, I say I against humbly submit that it is in
No,
my
humble
favor on
submission-
the ground. On the ground.
Mr. I also equally very humbly bring to your kind notice that look at the strength of this Satish Kumar Gupta. This is a two-judge bench decision. First page ku jaan. Mr. Das kindly assist.
My lord.
It's a two-judge bench decision. But now look heavily lignite.
Before I elaborate,
Can you just look at Navy Lignite? I'd most humbly request you to, at least when placing the decisions,
elaborate କରିବା ପୂର୍ବରୁ ମୋତେ if I am allowed to say
no, you are fully allowed. Don't pretend that you are not. As if to, এটা কোন ये Navy Lignite. সেটা click করନ୍ତୁ. Navy Lignite click করନ୍ତୁ. Just look at the bench strength of Navy.
yes,
ସେଥିରେ ଆସୁଛି ସେଟା. Okay. Navy Lignite is a three-judge bench of the Supreme Court. Now the two-judge bench in Satish Sharma reiterates Navy Lignite is very clear also. Actually, they don't have a case if they're post-acquisition beneficiary like Satish Kumar Sharma. Somebody purchasing land in Gurgaon from the Haryana Industrial Development Authority cannot question how much money, like if they question railway or somebody, whoever is allotted the land in railway by the railway, they cannot question. So that's the short point, and they reiterate Navy Lignite. So the other difficulty is that Navy is a three-judge bench decision. Satish Kumar Sharma is a two-judge bench decision reiterating Navy Lignite. So those Navy Lignite principles have been again and again reiterated.
in Gregory case it is decided. My lord, before I say make a submission,
No.
my humble submission before my lord is
Sir, only I am trying to assist you that the best case, whatever is there, you are relying on Satish Kumar Sharma, is the case you are relying on. That is directly against you. Para 15. Para 15 of Satish Kumar Sharma is against you. So you must cite a decision which, at least for Supreme Court, which favors you. That is how I am assisting. All this time I am spending. So that is the purpose. To assist you that you cite a decision if at all. If it is not there, it is not there. That is the advantage. You can present a case, whatever is there. Yes.
but my lord, ମୋତେ ଟିକେ ମୋ ଭାଷାରେ କହିବାକୁ ଦିଅନ୍ତୁ.
No, no.
ଟିକେ ମୋ ଭାଷାରେ କହିଲେ
Please don't use interpretation as far as Supreme Court judgments are concerned, because I cannot do that. A single judge or a division bench in High Court will start saying about mo bhasare mu kahibi Supreme Court decision mu likhibi. No,
and
that's
the
not-
expression that I'm acquainted with, I may
no, no,
seek
no.
liberty to
Please, as far as
to place
Supreme Court decisions are concerned, judgments are concerned, we cannot do
What-
that to Supreme Court. We have to.
But I have understood that if it is acquired at all for a purpose of the company,
No, that-
as given in the
Sir,
4.1
Sir, please,
notification,
when you are citing a decision and referring to the decision, refer to which part you are referring. I cannot. You don't give a commentary on the decision. You straight away, Satish Kumar Sharma is there with you. Which paragraph you are relying on? Straight away go to that. You have placed whatever paragraphs. That is how you see. I could have very well dictated that Satish Kumar Sharma para 15 is completely against what the point, the proposition you are making. But I have a purpose in sharing with you, because you must what the court is thinking. Though I am not bound to, because you are citing a Supreme Court decision. That is binding on me, binding on the other side. So is it necessary that I will elaborate on that to show you that Satish Kumar Sharma para 5:15 is against you? Naval Ignite is a 3-judge bench decision. Satish Kumar Sharma relies on actually Naval Ignite. That as far as post acquisition beneficiaries cannot be added as a party as per Naval Ignite. That's the short point.
Milord, keeping that in view, Milord, but that is even the other aspect is the other case that is decided in AIR Online 2022 Supreme Court 986. Here it is for the company. What I beg to submit, if in 3 lines I may submit, thereafter I will go through it. Milord, the question is,
Sir, whenever, again, I will most humbly request you, whenever you are citing a decision, please refer to the paragraph and the point that is decided.
yes, Milord.
Let us not go in a way without looking at the decision.
In paragraph 9,
Citation of paragraph.
paragraph 9 টা দেখুন। That again in case of Gregory Patra, my lord,
2210 SEC 461. Yes.
461, yes, Milord, yes, Milord. तो से डिस्टिंग्विश कर देछन 1980 ରୁ 1995 पर्यंत लॉ वाज जहां पाई एक्वायर हबो लोकल अथॉरिटी इज ए नेसेसरी पार्ट जो नहीं नथिला आगु।
Sir, let us not discuss here and give a commentary on the Supreme Court decision. Please refer to the paragraph of the Supreme Court decision.
Yes,
which you are
ma'am.
relying on.
Yes, yes. That in para 12 ରେ ମୁଁ ଦେଇଛି ଗୁଡାକ ହାଇଲାଇଟ୍ କରିଛି ମିଲର୍ଡ if my lord will and I have quoted paragraph 13 ରେ ଅଛି।
Sir, kindly mark
13 ରେ page 8
Gregory.
page 8 of my
You
submission।
are having Gregory.
ଆଜ୍ଞା?
Gregory ଅଛି ଆପଣଙ୍କ ପାଖରେ?
Gregory
ଆପଣ ମୋ-
Gregory case ରେ
ସବୁଦିନ ବଢେଇ ଦଉନାହାନ୍ତି।
case ରେ
Eh?
that was the acquisition for a
So,
company
which
but
paragraph?
court held
Just look at Gregory. Just look at Gregory. Subuchi. Look at Gregory. It's again bench 5-judge bench. Constitution bench has to say that Naval Ignite is not correctly decided. Just kindly
if my lord has got that judgment Gregory Patra case
more I have the advantage of using
ନାଇଁ ଏବେ ଅଛି ଯେ ସେଟା ମୁଁ ପ୍ଲେସ୍ କରନ୍ତି ସେଇ
sir, after holding that I am requesting you, when you started speaking in Odia, it is sir দেখেন sir
para 53
দেখেন এই পটে দেখে কাচড়ে দুষিওনি satisfied sir দিয়ন মতে দিয়ন দেতে টয়লেট আপনার স্যার না yes
para 53
পরে ଟିକେ প্লাসিটমটা দেখিবে গ্রেগরি পাত্র just look at the placitum
Gregory Patra para 53 ଟା ଦେଖନ୍ତୁ
Placidum take just dekhi diyo. You'll have a you'll realize what the Gregory Patras have. Placidum ବୁଝିପାରୁଛନ୍ତି sir? ଯୋଉଟା ଆରମ୍ଭ ହେଇଛି ଯୋଉଠୁ ଡିସିସନଟା
ଡିସିସନଟା ଆରମ୍ଭ ହେଇଛି
ହଁ ସେଇଠୁ ଦେଖନ୍ତୁ ପୁରା ହେଡ୍ ନୋଟ୍ସ ଯୋଉଠୁ ଆରମ୍ଭ ହେଇଛି
ଆଜ୍ଞା
ଦେଖନ୍ତୁ
କର୍ଣ୍ଣାଟକ ଇଣ୍ଡଷ୍ଟ୍ରିଆଲ ଏରିଆଜ ଡେଭଲପମେଣ୍ଟ ଆକ୍ଟ କିଆଡ ଆକ୍ଟ
ତାର ଜଷ୍ଟ ଆପଣଙ୍କର ସେକେଣ୍ଡ ସପାରାଟା ପଢନ୍ତୁ land acquired under provisions of KIAD act ଗୋଟେ ବୋଲ୍ଡ ରେ ଲେଖା ହେଇଛି following ପେରାପା
ପ୍ଲାସିଡମ୍ ବି
ହେଇଥିବ ଦେଖାଯାଉନି ମତେ
precedent binding nature subsequent decision in which earlier decisions were considered and distinguished by
ନାଇଁ
Supreme
ନାଇଁ
Court
ଆପଣ ଟିକେ ସେଇଟା
is binding upon and not earlier decisions.
Don't do that. Don't repeatedly read here and there. That doesn't look nice. You are being watched also. I am being watched. Look at the placidum in the bold following Perappa.
My lord.
Mr. Das, can you please assist? Look at the placidum top second sufferer following Perappa 2015-10 SEC 469 held.
AI online placidum should get different.
You are holding air online.
Air online 2022 Supreme Court 986.
Para 7.7.
So 7.7 more nahi thre.
It reads if you are holding a different further submitted there. So that you mark the submission. When what you are arguing is not submitted.
Nahi. In air online there is no para 7.7. However,
ठीक ଅଛି एका जिंस doesn't matter. AI online is a correct citation, good citation.
that is there enclosure 3.
Can you please hand over your copy to me?
Enclosure 3 that is also I have
ଆପଣଙ୍କର AI online copy ଟା ମତେ ଦେଇଦିଅ ଏ ନେଇ ଆସିଲେ ଦେଖ
ଆଜ୍ଞା ଟିକେ ବୁଝିଗଲେ ସାର୍ ସିଙ୍ଗଲ ଆଉଟ୍
Sorry, 7.7.
Just you know, double tick mark this is the point actually. Held in just simply has followed Satish and at Perappa Hanumanta Harijan. So it is not supporting you. That's the problem. Se jo double tick ta padhuntu kon lekha heichi tar thire.
Here also the same thing. Fact is same.
Sir, here also the same thing lekha hai. Double tick ta padhuntu. Kindly read double tick.
Again. Acquisition proceeding interested person who is land acquired for industrial development under Act of 1966 and not under Land Acquisition Act in 1894. Subsequent of a portion of land post acquisition cannot be termed as beneficiary
Stop there.
or
Stop
person
there. So
interested.
you got the answer. Subsequent allotee cannot claim that
Yes,
so
here the case is also same. Here the
so
company.
they will answer it. So if there are subsequent allottees of the land, so they will answer it. Relying on the decisions rendered by the Honorable Supreme Court. In Satish Kumar Sarma,
Satish Kumar Gupta, my lord.
Satish Kumar Gupta
My lord.
versus Haryana Industrial Development Corporation.
State of Haryana and others.
State of Haryana and others. Colon 2017 into bracket close 4 SCC 760 and Gregory Patrao GREGORY space PATRAO versus Mangalore Refinery and Petrochemical. Colon into bracket 2022 bracket closed 10 SCC 461. It is submitted by the head of counsel for the appellate that the intending interveners, intervention allowed in
No.
the intending interveners are subsequent beneficiaries of the land acquisition process. Therefore, as per the law laid down in Satish Kumar and Gregory Supra, Satish Kumar Supra, Gregory Supra, they are neither necessary nor proper parties. Parties before the LAA referral court. Yes, any other point? Gregory and Satish Kumar, your submission is that these intending interveners are
Not
subsequent
necessary or
beneficiaries,
proper party.
so they are not entitled to be parties.
They have no locus.
So,
That's the point.
they have no
And-
locus standing. Not necessary proper parties, they have no locus standing.
Annex, keeping in view of annexure 1 by 1. That is, I have given the gazette notification of 4.1 notification itself.
In view of the section 4.1 notification.
In my objection, that I have also enclosed that.
What index?
Annexure 1. In my objection to
Yes,
the intervention petition,
bracket annexure kete korchenu sir?
my lord may
Annexure
can have a
marking
glance
mode
to that also.
Annexure mark hai nahi. In the annex to the objection 4.1 notification dated 7/7/2010. Annex to the objection. Marked as annexure 1 by 1. What is that marking? Apanakar nahi index to jana paduni.
Annexure one by one.
One by
Page 8 million, 8 to my page 10 to my objection.
Then page 11, 10 more.
Page 11 to my objection. Because during continuance of appeal, they have filed the petition to be intervened. To that, I have filed objection along with this 4-1 notification, which says that it is for Sarvajanika Uddesya, public purpose.
No, they are not disputed.
No,
Yes. Any other submission?
Can I have a glance to section 4-1?
No, sir. 4-1 I have recorded, sir. As per the 4-1 notification, it is for public purpose, and as per that annexure, they are not entitled to be necessary or proper parties, no local standing. Yes, so that is recorded already.
My whole attempt for making a submission that 4-1 specify either it will be acquired for the public purpose or it will be acquired for the company. Kindly bear with me for a moment. Kindly bear with me. Either it is for the public purpose or for the
I am
company
simply saying that according to 4-1 notification,
kindly
I have
bear with me.
recorded that.
Kindly bear with me for a few minutes.
No, I have been bearing with you for more than 1.5 hours, so no difficulty in another 2 minutes. I am saying something else, sir. I have noted your submission. That I am saying.
Next line. If it is for public purpose, then no difficulty. If it is acquired for the purpose of local authority or the company,
if it is for public purpose, no.
If it is for the public purpose, because public purpose is different and company purpose is different. For acquiring of the company purpose, part 7 of the land acquisition has to be mandatorily followed.
That is not issue.
Here it is not that.
I am not adjudicating that.
Here it is not acquired for the company. It is acquired
4-1
for the Union of India.
4-1 notification, neither you are challenging nor they are challenging. I am not adjudicating whether 4-1 notification was for a public purpose or for a company under section 7.
The 4-1 shows that it is public.
Let us. You are very well aware of the provisions of the Land Acquisition Act, and you have seen me in how many land acquisition matters I have appeared. So that let us not discuss those things. That is beyond scope of my adjudication, because I am on a very simple point.
Here there, got the point. Yes. Here there is no compliance of the mandatory provision, that is part 7. Part 7 is the purpose. If acquired for the purpose of company, it has to be mandatorily followed. Here it is not that. It is here for Union of India, the requisitioning authority is India, the Ministry of Railway, and they have acquired, they have taken possession, they have paid the amount.
Requisitioning authority is Union of India, the Ministry of Railway.
I may solicit
by the as per the orders of the
if railway comes,
Honorable
if Union of India comes and challenges, I have no hesitation. Here Union of India agreed and paid my ticket.
The President of India. Therefore, railway is not a necessary party, much less the project proponent executing the project.
Railway can
Yes,
do.
any other
If my lord will allow me 1 week time so that
No,
any other point I can
go
also.
for the time after almost
Up to mine.
1.5 hours, sir. Because I have to be reasonable. I can't keep on adjourning matters,
Up to-
and that too so many this say 11-year-old matter after 1.5 hour of hearing. If you have any point, please submit. So I'll record that he was asking for further time, and I don't.
I will file a note of submission if my lord will allow.
already there.
I
Beyond records in an appeal, going is always a
No, not-
problematic thing.
I will not submit any beyond record.
Your notes are already there.
I will not submit beyond record.
Counsel for
I will submit if my lord will allow me.
Extenso went through the notes of submissions, but at lab. Yes, who is for the interveners? Mr. Das.
Lord, at the outset, your lordship has already noted the cause from the cause title that neither the railway nor the project proponent, they have been made parties. And under section 12(2) also.
Since you are a learned senior counsel, you are the officer of the court. in their favor, could you find anything also that you can answer?
My lord,
That wherever they have been referred to or made a party or issued any notice, if it is within.
nothing is there. My lord, what has happened, my lord, the main contention, what has been urged, that while deciding the case in that, Pitambar Sahoo's case, your lordship has seen it. It is said that Gregory Patro has judgment was not noted. This is simply astounding because whatever has been decided in Gregory Patro, that was decided in another Karnataka case, which was taken note of by the Honorable Single Judge of this Honorable Court. And then it was decided.
Perappa.
Yes.
Perappa.
So, my lord,
That in
before Gregory Patro, there were several judgments on the line that post-acquisition allottee, they are not necessary parties. You will also may recall the case of Mahanadi people. They were allotted from the development authority after the acquisition by the government. But the post-acquisition allottee, when they said that the compensation amount has become enhanced, the Apex Court didn't entertain it at their instance.
Satish Sharma.
Yes, my lord.
Maybe Mahanadi Vihar is prior to Satish Sharma.
Prior to.
Because I think Gurgaon was not that developed when, by the time Mahanadi Vihar is in early 80s.
Yes, my lord. It's this position. And if the same or similar line of judgment has been taken note of in our honorable court while deciding the case, then, my lord, what remains? And I will also invite your lordship's attention to one of the judgment.
So, my reading of Gregory Patra, Satish Sharma, Perappa and other decisions is that is on a completely different point.
My lord, I bow down to that.
The other difficulty is that para 15 of explicitly Satish Sharma in para 15, Satish Sharma is actually relied in Gregory.
Yes, my lord.
Gregory has followed Satish Sharma.
And in that case also they have
they have in fact approved heavily.
Yes.
Because if either you are a project proponent or a requisitioning authority or you are a post allottee. Whether post allottee has a role as far as
no, my lord. Post acquisition allottee will have no role.
Now the court has not favored except that particular decision which has been distinguished.
In
one case, UP Awas and Vikas Nigam, only that case, somewhat post allottee has been considered to be a person to be afforded opportunity, but the law still remains that that kind of decision that post allotment beneficiaries, you can say.
Beneficiary, they are the beneficiaries.
Beneficiaries like Mahanadi Vihar or your Gurgaon or any other.
And here also, my lord, I will invite your lordship's attention to one of the orders that was passed by a division bench of this honorable court, where UP Awas Nigam was taken into account because of the fact that if an award has been passed in like manner, then the remedy is also available either by filing an appeal or by filing an application under 226. That was said in UP Awas in 1995 Supreme Court. And then even referring to that Gregory Patra.
UP could be a correct view.
Yes, my lord.
UP also could be a correct view because in a residential project, and if the proponent has to pay and collects it from like Noida.
Yes, my lord. There they say.
Or Gurgaon or Mahanadi Vihar, CDA. The project collects the money from the ultimate beneficiary, it will be exorbitant price.
Yes.
So maybe UP Vikas has a future in some case they will consider in what circumstances. Even post acquisition beneficiaries could be effective, could be a necessary party. But till now, Gregory Patra, that Satish Kumar.
But my lord, I will put it and word to it. Even accepting that for a moment that they do have a right to be implemented, then nowhere it is said that the other persons who are to pay the compensation amount like the project proponent.
No, that is what is Neville.
That goes with the
being a 3-judge bench.
So that becomes too broad.
Unless, because you see the difficulty for Mr. Panda is that to contend. Either he has to contend that you are a post-allotment beneficiary.
Yes.
Then you can come within, but that is not his case.
That's not
his case.
And your lordship,
he says that the land acquisition officer, Mr. Swai's client, is made a party, and once they are made a party and they inform that the requisitioning authority, that is enough. But then in a proceeding,
court has to
see to what extent level it goes. It It is violation of fundamental right.
Yes, please.
Article 14, if the affected party is not made a party in the proceeding before under section 18, it violates fundamental right. So that sort of distinction is also not made in subsequent decisions also. They will
No.
still holds good. So that is how I was asking if any other decision is there, Mr. Panda can cite that even a project proponent need not be a party. Either distinguishing leveling
But
or
that-
a larger bench, high
No,
judge bench.
that's a constitution bench judgment where it is said that if a money is paid by a project, then he has a right to be
That is which
heard at any stage. EP Abbas
DP Abbas.
is a 5-judge judgment. That is, if your lordship may kindly see the citation, not in SCC, 95 Supreme Court 724.
This order I have referred to because already Mr.
Yes, madam. 95 Supreme Court. Here, base. Your lordship may kindly come to the last of the DP Abbas case. Order of
the citation. Kindly put the citation.
my lord, 1995 Supreme Court 724. AIR 1995 SC 724.
Just a second. I'll get it.
Your lordship may kindly come to paragraph 49.
I'm just getting it. Just give me a second. Yeah, 1994.
95.
Supreme Court. So page.
My lord, got it.
Page.
724.
724.
My lord.
SCC equivalent citation is 1995 to SCC 326.
Lord. My lord, may come to the last paragraph. The view on majority has been indicated in a capsule 49. Here it is 49 there.
We're going to the last paragraph.
Last but one.
What it reads, we therefore, sorry, kindly read it.
Order of the court, bracket, for majority.
Leave granted.
49, leave granted. Yes, my lord.
Yes.
1, 2, my lord, I'm reading out from 2.
Yes.
Sorry, 1. Section 52 of the LA Act confers on a local authority from whom land is being acquired a right to appear in the acquisition proceedings before the collector and the reference and adduce evidence for the purpose of determining the amount of compensation. The said right carries with it the right to be given adequate notice by the collector as well as the reference court before whom acquisition proceedings are pending of the date on which the matter of determination of compensation will be taken up. The proviso to section 52 only precludes a local authority from seeking a reference, but it does not deprive the local authority which feels aggrieved by the determination of the amount of compensation by the collector or by the reference court to remedy under Article 226 of the Constitution, as well as the remedies available under the LA Act. In the event of denial of the right conferred by section 52 on account of failure of the collector to serve notice of the acquisition proceedings the local authority can invoke the jurisdiction of the High Court under Article 226 of the Constitution. Even when notice has been served on the local authority, the remedy under Article 226 of the Constitution will be available to the local authority on grounds on which judicial review is permissible under Article 226. The local authority is a proper party in the proceeding before the reference court and is entitled to be pleaded as a party in those proceedings wherein it can defend the determination of the amount of compensation by the collector and oppose enhancement of the said amount and also adduce evidence in that regard. In the event of enhancement of the amount of compensation by the reference court, if the government does not file an appeal, the local authority can file an appeal against the award in the High Court after obtaining leave of the court. In an appeal by the person having interest in the land seeking enhancement of the amount of compensation awarded by the reference court, the local authority should be pleaded as a party and is entitled to be served notice of the said appeal. This should apply to an appeal in the High Court as well as in this court. Since a company for whom the land is being acquired has the same right as a local authority under Section 52, whatever has been said with regard to a local authority would apply to a company too. The matters which stand finally concluded will, however, not be reopened.
We therefore allow the application.
This has been, my lord, taken into account in that our honorable court
Yes.
by a coordinate bench, which my lord has also relied in passing orders in the case of Hardaspur Railway, which is a project proponent for the land acquired in respect of some other area.
Yes.
And this is Honorable
Sukinda
Sukinda Dubri. And the
what is
minister,
your answer to this Satish Chandra and
Satish Chandra, my lord, a similar line, as your lordship found from the facts of the case, that it was the land which was acquired. Thereafter, the development authority allotted in favor of some persons. They cannot raise a grievance of the enhancement which has been made in the land acquisition proceeding because they were not integrally connected with the land acquisition proceeding. Here, the acquisition is made for the railway and there is a agreement approved by the Ministry of Railways that this Hon'Ble Sukinda Railway will pay the amount.
Right.
And repeatedly it is also being said that the project proponent, they are paying the money, and even if a execution case is filed for realization of the amount, then again they will implement this. How can then now be said that in absence of them, the amount will be either determined or enhanced?
how in fact it doesn't inure to the benefit of the oustee also.
Yes, my lord. It will be.
Oustee enforce an award.
It will be to their benefit. It will be to their benefit if it is decided in presence of the company which pays for it.
So like Haridaspur, I have said that it will be allotted to, you will be included as a party.
Yes, my lord.
Both the parties shall cooperate.
Yes, my lord.
So, I mean,
Matter will be adjudicated finally within a given time.
Demanded and after including the railway and or even you as because since railway because the other point raised is that railway is not made a party. So maybe railway is not interested because this
Because money is paid by us. That's.
And even I was asking that how the money is collected. That it's again a complex thing. There are so many persons contributing money for this acquisition.
Yes, miss, your lordship.
So that is other part, in fact. Yes, Mr. Panda.
My lord, may I be permitted to say one line to
Please,
reply? My lord, had it been a local authority, I have no objection. Had it been a company for whom it is acquired, I have no objection. It is not the company for whom it is acquired. So I have objection. It is not a local authority. So I have objection. The only point, and that is the reason that para 7.3, it has been distinguished. The 1980 Supreme Court says, if it is acquired for the purpose of company or for local authority, it is a necessary part.
One humble request, whenever you are referring to any Supreme Court decision, 1983, all these things, please give the paragraph and the reference. So,
Yes, madam. What is that? Kindly, 95 Supreme Court, page 724, he is referred to. That is that case. It is here. The highlights he has made in the conclusion that necessary party he is, if it is a local authority or for whom it is acquired for the company.
Where,
I have no objection to that.
sir, where
That
is
has
it?
been distinguished in para
Mr. Ponda,
7.3.
Mr. Ponda, kindly, don't, it is not, you are the only person in the court. Who particular paragraph रे आपण कहउचंदी सुप्रीम कोर्ट जोटा कोटा आपण फेवर रे जे जो कन्फ्यूजन 42 से साइड कले
My 7.3 of AR 22, AR online 22 Supreme Court page para 7.3. That has been taken care of and has been disclosed. I am placing it.
That constitution bench decision which Mr. Das
Page,
cited. Kindly listen, Mr. Ponda. So, if you are you having a citation copy or can you janu
Gregory Ponda. Gregory 7.3.
And he is not citing Gregory. He is citing a constitution bench decision.
Yes, my lord. That 95 Supreme Court
So
page.
95 Supreme Court Gregory has not clarified DPA on that. So
Gregory case has distinguished that on the ground because if the land is not acquired for the purpose of company compliance of part 7, then it is not a part. It can be a part. That is the point.
Which paragraph of Gregory you are saying?
So I just bring to
Sir, which paragraph of Gregory?
7.3, my lord. 7.3 kindly have a glance. Because all those decisions that has been Himalayan tiles or 95 Supreme Court, it is better if it is quoted in 60. In my page 23.
Just a second. I'm just getting
7.2, my lord.
Kindly just give me a second. Get Gregory. Plus, be patient. I have showed you that I can see Gregory here. Please just wait. I'm getting the page.
7.3 it is concluded that this court thereafter had considered the decisions in the case of UP Abbas, Ibam, Vikas Parishad, Supra, and Himalayan tiles and marble, etc.
Wait, sir.
And has distinguished.
Give me a minute before you start shouting or reading. Please wait. Response, the learned senior counsel, Mr. S.K. Das, instructed by Mr. P.C. Das. Mr. S. Das, I'm sorry, you are Mr. S. Das.
P. Das, my lord.
Mr. P. Das relies on the decision rendered by the Supreme Court in UP Abbas and Vikas Nigam, Constitution Bench, Supreme Court, UP Abbas and Vikas Nigam, in AIR 1995 SC 724 colon 1995 2 SCC 326, particularly paragraph 47 of SCC, where the court has given its conclusions. The Supreme Court has given its conclusions. It is submitted that the fact and issue involved in Gregory Supra, Satish Kumar Supra are different. In those cases, the subsequent purchaser / beneficiary of the land acquisition wanted to be parties in the NA proceeding or the reference before the civil court. Answering that question, it was held in Gregory. It was held in Satish Kumar. Satish Kumar reiterated in Gregory that post-acquisition beneficiaries are not necessary or proper parties or necessary or required to be made parties in the LA proceeding or the reference. The paragraphs 47 onwards are reproduced here from UP Awas Vikas Nigam. (1995) 2 SCC 326. Agenda. Mr. Panda, learned counsel, appearing for the appellants. You dot today EVA Vikas Orissa EARISHAD versus V dot Gyan Devi GYAN space DEVI. Yes, Mr. Panda, you are relying on which paragraph of Gregory Patrao? Mr. Panda, which paragraph of Gregory Patrao?
Gregory starts from 7.2. 7.2.
7.2.
Paragraph 7.2.
7.2 is submission of the council. That's not the finding. Para 7.2 of Gregory, just look at it.
Gregory case.
Or that. So that is not the conclusion.
And 7.3 is the conclusion.
7.3 is
7.3 is the conclusion.
7.3 kindly read.
This court therefore thereafter had considered the decisions in the case of UP Awas.
SEC. Put up.
7.3. See Gregory Patra.
Air online.
Air online.
Air online.
Air.
कौन ठीक है मार्क करके मते दे दियो so that I can go. Just
with other cases, 95.
7.3
724 has been taken note.
65 ଆପଣ 65 को 7.3 କହୁଛନ୍ତି এটা ଆପଣ ଗୋଟେ ପୁରାଟା ପଢିନାହାନ୍ତି. This is paragraph 15, not 7.3. तो para 6 টা পড়ে যায় একদম para 6 টা পড়ে. The question is different. That is how when they are quoting other Supreme Court decisions, you are thinking that that is the observation. Para 6 টা দেখুন, just read para 6. ଆପଣ ଫୋଲ୍ଡ କରି ଦେଇଥିଲେ, ଆପଣ ତ ଉଲ୍ଟେଇ ଦେଲେ ଆଉ।
Yes, my lord. Para 6.
7.3 जोड़ा रेफर କରୁଛନ୍ତି ସେଟା ଆଉ ଗୋଟେ decision they are quoting.
That is the question raised in para 6, my lord.
ପଢୁ ନାହାନ୍ତି।
The short question which is posed for the consideration of this court is whether respondent 1 MRPL, that is that company there, who is simply an authority of the
Stop
land
there, stop
by
there.
the care board.
So kindly, so that you are missing. So they say that even if we are a allotee, still we need hearing in the proceeding. There the interveners have no effect because they are not allottees.
Here they are allotted with because they have for 30 years lease agreement has been made, and
it is
if they
submitted-
cannot recover, that I have also given in my objection.
So where kindly show a document or a pleading that they are the allottees. They are not the refugees.
Yes, that I have said in my objection also.
Sir, in the before the LA collector or the proceeding, that they are not. They are in fact
Here they are
somehow you have placed the 4-1. Look at 4-1. Where 4-1 is by the railway. So you can't say that they are the allotee. They are the requisitioning authority.
no, my lord. That is my submission may be noted. They are not the requisitioning authority. The requisitioning authority is the railway.
Yes, yes.
That is why I.
4-1 requisition is there, answer one.
Yes, yes.
Yes, that
Not allowed.
That is the railway, my lord. For a kind have
They have only come-
my lord.
They have come only to the picture by signing a MOU. The intervention application filed by the present intervener.
Company.
Just a minute. Take a room. They should have given the MOU when the MOU was signed. That has been after the land was acquired under some foreign notification has been issued. So any right accrued after thereafter, they are not necessary parties to commission rules. Because they have no right at the time of acquisition of the property. Subsequent right, they cannot be.
The problem is that
Now what is the MOU? Whether they are actually liable, the intervention petition actual place, they say we are likely to be affected.
No,
So
it's
whether they
that-
are really affected or not, that is
the
also
thing
not.
So the thing is that the company who has been assigned the work by
Yeah.
the government of India.
Subsequently.
So these decisions nowhere actually help the
Suppose MOU with him. Now that MOU will be cancelled. Another person will come. Then again he will be played as a party.
so Mr. Swani, that is predictive.
Yes.
Suppose cancelled or not, that's a question of fact. What you are saying,
Yes.
if it is your submission, what Mr. Ponda, maybe he is not assisting to that extent, that is there any decision that a subsequent allotee and a project proponent.
Yes.
What is the distinction?
The project
Because
my-
then you read Naval Ignite and
Yes.
this.
No, the decisions are there. Lordship has gone through that. All decisions are there. But what I understand from the decisions that any project proponent at the time of acquisition of the land.
That at the time of acquisition of land is not there, nowhere. That is your addition. That is your nowhere. It is written that at the time of
If they are
deals with.
Yes,
You see, UP Awas and Vikas Nigam, I didn't realize that it's a constitution bench decision. Even that goes beyond Develi. Develi is a 3-judge bench. Patrao and this Gregory Patrao and Satish Kumar Sharma, 2-judge bench.
yes,
And they only consider whether, like Mahanadivya,
Yes.
Gurgaon,
Yes.
the subsequent allotee can have a say. So
Yes.
that they say they do not have a say.
Yes.
But the question is, suppose this special purpose vehicle is formed, they start constructing, they pay the land acquisition cost. Then you have to say that this particular company is not paying land acquisition cost. That is as simple as that. You are saying that though they are paying, I mean, I'm just formulating what you are saying.
yes, yes.
Though they are paying the land acquisition cost, but since it is because of a MOU, they are not to be parties. That is not the decision.
No, here they are.
That is not the decision. Suppose-
What they say, 2016 intervention application has been filed in 2016. They say by virtue of this MOU, we are likely to be affected because we may ask for payment of the
No.
enhanced amount.
That is their case.
They are saying that we are paying the land acquisition compensation.
Not paying, we're likely to pay.
Mr.
I'm placing it. I'm placing it. I'm placing the just a minute. Paragraph 3, intervention company is likely to be saddled with liability to pay the compensation amount.
Likely to be saddled with compensation.
Yes.
So,
that
for that,
MO
for that, if it is your contention that they are not paying the land acquisition compensations, bring it on record.
let them produce the MOU.
No.
That is they are the interveners. They are the interveners. They are
The court is not conducting an inquiry here.
No, they are the interveners. They have to come with a positive case.
If you are saying that they are not paying the land acquisition compensation,
That is no
the
material.
interesting part is that your land acquisition officer has said that they are paying. Just look at it. That's the problem.
Then should have been immediately be made parties before the civil court.
You see, in the whole process,
If they are aware of the fact.
I was asking the younger Mr. Ponda,
Yes, yes.
what you are doing.
Yes, exactly. What they are doing.
Think about the land ousting. You don't make the party. You see, this litigation may go to Supreme Court. That's not one thing. But what about this land ousting?
But
He is stuck at a point.
This
He is stuck at a point where the liability to pay is denied on the ground that only on the ground that since we are not made parties in the proceeding.
if they are aware of the fact that they are going to be saddled with the enhanced cost, they themselves could have been made a party before the trial court.
Mr. Swai, look at the trial court's judgment and order. No reference.
No, they are aware.
No reference. Suppose they know everything.
Yeah.
Can they be in a judicial process? Can anyone be attributed knowledge, not being noticed, not being made party? That is the problem. That is the question. Now this court has to answer. Suppose it is such a simple thing. They may pay, they may not pay. That. In fact, when we started discussing this, I was telling Mr. Ponda that they may have to pay more, much more. But we do not know.
Yes.
But now the issue is that they are not made parties. On that ground, the litigation continues. And in fact, in Haridaspur case, I have already said, because the counsel there, they said that we cannot defend it here without their readings on record.
But because they are not.
Suppose they are supposed to pay.
No.
So kindly listen to the formulation.
Yes.
Nothing is on record.
Yes.
Nothing is on record. Whether they are liable to pay, not liable to pay, they are
Nothing.
liable to pay enhanced amount. They say that we will be affected because there is a likelihood of we will be saddled.
Yes.
That you are saying we do not know whether they will be saddled.
Yes.
How the land acquisition collector then said that they have to pay it.
No,
The
land
land acquisition collector,
I've not checked of them.
even in Haridaspur,
No, if
if you are saying that you will pay, suppose, then I'll pass that order that the land acquisition collector will pay.
So if land action officer ultimately held that their intervener is to pay, then they are necessary.
He has not held. It is held by the land acquisition officer is a party in the proceeding.
Yes.
No one else is a party.
Yes.
In Sukinda, in Haridaspur Paradip, at least the construction company is a party, contractor. Rail Vikas Nigam is a party.
Sorry.
Here, no one is a party.
Neither
Now the court passes a decree. Just look at the decree. No reference to who will pay. Who is the judgment debtor? Nothing.
they are the
Nothing.
In that case, East Coast Railway is a necessary party.
Suppose now
So
now you issue the rec of the MOU. This court at this in the appellate stage, because when the London trial court has not considered the MOU even, nothing, no reference. You just look at it, look at the judgment. Has not delved into that aspect.
My lord, I have also quoted some relevant paragraphs from the MOU. That will also maybe answer.
Don't expand the pleadings. Appellate court has the limitation of going through the available.
Of course, because this divisional bench has
if you have that, Mr. Ponda, if you have that in the lower court records, you place it. Don't throw around papers. That's not the way. You refer to the judgment.
I have included.
Kindly listen. You refer to the judgment, the pleadings, the evidence. That's it.
But may I take my lord to that
Just
order of read court?
Just look at the last page of the judgment, Mr. Swai.
Yes, please.
Mr. Ponda, kindly sit down.
Yes.
Don't interrupt Mr. Swai also. Because when we are discussing, you have started saying something which I cannot hear basically. And it is more problematic. in
I'm
micro-
just assisting my.
So he's very capable. Be confident about it. Just look at what he has relied upon.
The operative part of the order, the market price of acquired land is determined at rupees 51,41,905 per acre as on the date of notification. The petitioners are entitled to get compensation at such higher rate for the acquired land. The special land acquisition officer, Hon'Ble Duburi Sukinda Road, new BG rail link project, Denkanal, is directed to reassess the compensation at such higher rate for the acquired land measuring 0.55 decimil, BL plot number 1 and to pay the same to the petitioners. Yes,
So,
and
so he says he will pay. If you say that you will pay, then I will not enter and close the brief. If you read Neveli, if you read that UP Awas Ebang Vikas, so that is very interesting. In fact, that the land acquisition officer never pays anything from his pocket.
because he has to ask for the requisition. also.
Exactly. That
He will
amount has
have
to be
to-
deposited.
he
Mr.
will have
Pata,
to-
kindly sit down. Don't interrupt. Don't interrupt. Please don't interrupt.
Now the land action officer will ask the East Coast Railway to pay.
Yes.
So they are going to be affected. Let them come and file application for intervention. We have no objection to that.
They are also now, I will direct that the matter will be expedited, they will be noticed and they will cooperate. This is for them. If they don't cooperate, the matter will be closed.
You will also may indicate East Coast Railway is also necessary party and let them be parties.
That
Both-
I was thinking.
both.
In Haridaspur, I was thinking that.
Yes.
But then the claimant as well as the intervener,
Yes.
they say that East Coast Railway has not challenged it. So maybe East Coast Railway will satisfy the demand. So that I cannot that I cannot say. So that is the reason I have, in fact, while observing that they will be issuing notice to so and so of giving the current address. Apart from directing them to appear, I have also directed that they will be issuing.
Yes, that will do. That will do.
One step
That
for
is the best.
clarifying this, your lordship also saw the judgment.
Don't interrupt.
Has paid the deposit.
Now you
Paid
you are hard for 1.5 hours. Mr. Swai has only spent 5 minutes or 10 minutes. Please wait. Let us arrive at something which can solve the purpose of your benefit.
I will only like to draw your lordship's kind attention to the judgment which my lord has already referred. That is in Pitambar Sahoo versus Hon'Ble Sukinda Railway Limited in respect of the same accusation, where this court in paragraph.
No, Mr. Das. It is like this. What Mr. Swai, just look at the order. Mr. Swai says that in that proceeding, the direction has been issued. That is how I was asking him. That who is to satisfy that enhanced demand, whatever calculation. Because in fact, interestingly, the referral court does not calculate it.
And doesn't determine who is liable to pay.
Who is liable to pay?
That your lordship has already.
No, so that is the difficulty. How to sustain that?
My lord, for
Then,
that,
then now Mr. Swai says that we will pay.
my lord,
That's
my
another.
lord, that's not the issue is taken up at paragraph 11 in that House case.
Oh.
The concession agreement executed between the Ministry of Railways and the opposite party company reveals that parties have agreed for setting up a suitable framework under which ASRL can undertake all activities connected with development, finance, design, construction, operation, and maintenance of the project. Then, my lord, I am not reading out the next thing which has been quoted from the agreement. Your lordship may come to the next page. Page 11.
No,
Where?
there, Mr. Das, what I have done. My considered view is that since already this aspect has been decided by Pitambar Sahoo versus Sukinda Railway Company, I am not reopening that issue.
My lord, that I am greatly.
So, Mr. Swai, I am not reopening. I am simply saying that the Pitambar Sahoo is to be followed. The project proponent or the special purpose vehicle is to be made a party because this Pitambar Sahoo is very elaborate on that.
Yes, my lord.
And they will be issued notice. They will be issued notice and they will be heard and the matter is to be conducted on daily basis.
Here my submission is the present intervener is not a project opponent.
Correct.
Yes, no.
So that SPV, but it is a SPV. It is not denied that it is
The
not
SPV, this judgment is there which has not been challenged by the state.
You also may say both, East Coast Railway and this. Both.
Yes, Mr. Das.
Yeah, and the MOU sign that will take care of both.
East Coast Railway, do you have Mr. Swai's submission is that East Coast Railway should also be noticed.
Yes.
That
And that
Yes,
MOU sign between
I
them,
do
that
not
will take
stand
care
to
of.
lose anything because it is only
Yes.
the arrangement between us.
Yes.
That is-
Yes, Mr. Panda.
My lord, that is why I just
East Coast-
draw my lord's attention that
No, no.
it is a private company has taken a lease on for 30 years with the term and condition. I have
Mr.
also
Panda,
put in
Mr.
some
Panda,
paragraph.
more you enter into those aspects, the litigation will drag and nothing will happen. No railway company in India is a private company. You will be surprised in Sukinda.
It is-
In Sukinda also, state government has funded. In Haridaspur Paradip, that Sukinda Valley project, state government has also funded. They have a stake. So this economics of bringing in railway projects, the finance of railway projects, is much beyond, it's much complex than we interpret. So railway will be also made a party as agreed.
My lord, I have no objection for railway.
Yes.
But
So
I
you
have very vehement objection for the company because company is a private company. It is a lessee. It is only a contractor.
Mr. Ponda, because of your vehement objection, only I heard you for more than 1.5 hours.
My lord, that
So
is-
all points have been noted.
my-
That's it.
because my lord is allowing me so that I am
We
something.
for a 14-year-old matter, we cannot adjourning for no point, for no reason. It is a 14-year-old matter. Still,
May I just at the last, may I just have a submission that my lord
Adjournment.
should go through the MOU between railway and the company.
You see, once this court has upheld that MOU and that to be and it has been adjudicated, that order is yet to be the judgment is yet. It is an order, but it's a judgment actually. But since it's a IA, Pitambar Sahoo.
My lord, that Pitambar Pradhan case, Pitambar Sahoo case.
I am not going into that. I will confine to the provision of CPC as far as this necessary or other parties are concerned. Yes. I'll dictate after recess.
Paragraph 16 may kindly have a glance. My lord, if my lord will be pleased to see.
Sir, आपको who decision is paragraph 16 पूछो?
Paragraph 16 of my objection.
I have put it. देखी चीज़.
16 and 17 may kindly have a glance to that.
16, 17. 5, 6, 10. 5, 10 ଆପଣ କହିଥିଲେ ତାପରେ 4 ପଢିଲେ ତାପରେ 6 ପଢିଲେ 16, 17.
ମାନେ ସେଥିରେ
Mr. Panda, I have
the relationship between
Mr. Panda, I have gone to the extent of asking Mr. Das and Mr. Swain which part of your
my lord is hard and my lord may decide. Because once last line I may make a submission, it is a claimant's appeal for further enhancement. If on merit there is going to be because I have already got my decretal dues. Now for further enhancement, whether it is entitled to,
it will be limited
I am entitled to or not. Only will be question.
Further enhancement has to be heard by the court by listening everyone, not like this. The award is made in air. The land acquisition collector will pay. Who will pay? What is the enhancement? What should be the enhancement?
Because
Nothing is there. So
because the railway has paid and I have received the amount.
Mr. Ponda, are you apprehensive that I will set aside the amount of land acquisition? No, it is not that. As far as the enhancement is concerned, to that extent, they will be heard and you will be heard. In fact, they
got the money from railway. Railway made a letter to them that you please deposit and pay them, and thereafter I was paid. Railway has deposited the money before the LAO for disbursement.
Mr. Ponda, I hope you are listening. As far as the enhancement is concerned, you have come because the enhancement has been rejected, or you want whatever has been awarded. So that to that extent, it will be remanded. That's it. So you are not losing the case here. Please appreciate that also. You are not losing the case here. You could have got that order in 2011 also. Instead of waiting for 14 years, you could have got that order directing the court to consider for enhancement by hearing all the parties. That's it. That's a simple order.
But before that, it is my appeal, Miller. I may be allowed some time to take an instruction from my client.
Please don't
if he
waste
wants
time.
to proceed further in the appeal order. If my lord will do that.
Mr. Ponda submits that even after 14 years, he will require time to obtain instructions. 14 years of filing appeal.
Suppose I do not continue with the appeal, then as per the instruction of my client, I can only
got further instruction from his client. such prayer is misconceived, as the appeal is kept lying for more than 14 years. I'll dictate the judgment after recess, since time is not there.
Uh, My lord, I
Please don't, Mr. Pandya, don't leave this habit of interrupting the court always.
ସେଥିପାଇଁ
I
କହିଲି
have spent,
ଅଲଗା କାମ I'm obliged.
sir, I'm equally
I have-
obliged that
I have been hard patiently
I'll be more obliged that if you please allow me to start dictating. Please don't.
Only
interrupt.
my lord, just
Sir,
I
please have patience. Let me complete
same
the dictation. Sir, you have the entire day to say anything, but I have some time to give for dictation. So I
My
can't
lord,
waste time like this.
if my lord will allow me
Please allow me to
to-
dictate. I humbly request you. Please allow me not to interrupt further after 40 years of pendency of this matter. Please don't interrupt.
49 2010 ରୁ client
15 years.
ବର୍ତ୍ତମାନ ଖାଲି କଥା ହଉଛି ଯଦି
Kindly,
I read the mind of
Mr.
the
Pandya, you were hard for about 2 hours.
yes my lord.
Please,
I'm
please
obliged.
sit
my lord.
Please sit down. Please sit.
Only if my lord will allow me to
Please
But
wait,
have
sir. Please don't make
have
any
an
further
instruction
submissions.
from my
Kindly-
client.
Kindly don't interrupt when the court is
That
dictating something. Please don't interrupt. It's
beg apology for that.
I beg apology from you to start dictating. Please, sir. One minute. Court is enough. And the prayer for further adjournment is also rejected. Is rejected. As made for the prayer for further adjournment as made by the Learned Counsel for the appellants is rejected. Whether there was any delay? No, it is in time. It's actually judgment pronounced in separate seats. Doctor, actually, good after. Yes. Here. ठीक ଅଛି। Order sheet complete ହେଇଗଲା। Judgment pronouncing separate sheets. Judgment and order pronouncing separate sheets. LAA 33 of 2014. Ramesh Chandra Patra and others versus Special LAO. Hon'Ble dash Sukindar. Road, new broadgauge rail link project at post PS district Dhankana. देखिए appellant respond. Appellants respond. The appeal under section 54 of the Land Acquisition Act 1894. LA Act काढिଛନ୍ତି? ଅଛି 1894 has been filed by the appellants who were claimants oblique petitioners in the court below. In the court below, a reference was made by the Special Land Acquisition Officer under section 18 of the Land Acquisition Act. As a dispute arose regarding the actual market price of the acquired land. The learned civil judge into bracket senior division, comma, bracket close, comma, Kamakhanagar, answered the reference by his judgment dated 04.07.2014. The land acquisition process was pursuant to a notification dated 7/7/2010, published in the Gazette on 5/8/2011. Stop. The appellant's land acres 0,55 decimals pertaining to plot number 1893, Isam Sarada AK, Moja Kamakhanagar, district was acquired for the Hon'Ble Duburi Sukinda Road, new broad gauge rail link project. The land acquisition officer determined the compensation amount at rupees 25 lakhs per acre, that is rupees 25,000 per decimal. Before the land acquisition, before the referral court, the awarded compensation amount under section 12 into bracket 2 of the LA Act, that is rupees 22,30, 966 as awarded, was disputed. The appellants objected before the LA collector by written objection, and they received the compensation amount with protest. The written objection was referred by the LAO, special LAO, that resulted in the adjudication by the civil judge, senior division. The claimants before the land acquisition collector claimed compensation at the rate of 2.5 crores per acre. The proceeding before the land acquisition collector has very striking features as far as implication of the parties. The judgment, as has been enclosed and available in the lower court records, indicate that the special land acquisition officer, Hon'Ble Duguri, repeat hala, took in the road, new broad gauge rail link project, was the only opposite party to answer the claim of enhancement of compensation amount. However, what is more striking is that the learned civil judge senior division has not framed any issue, nor answered, nor any evidence was laid as to who were the project proponents, who had deposited the amount of compensation as determined by the LA collector, challenge before the civil judge senior division. The issues framed by the learned court below is reflected in paragraph 4 of the judgment. Which is reproduced here. Para 4 internal case 3 of the produced here. The order of the learned civil judge senior division indicates the following. Quote karne order time. On perusal of the order of the court indicates that the amount of compensation awarded in the LA proceeding, that is rupees 22,30,966, was enhanced by the learned court to rupees 56,41,905 as on the date of notification. The special LAO so and so project was directed to reassess and pay the same to the petitioners after deducting the amount which has already been paid to him. The the judgment in the ordering portion or any of its paragraphs does not refer to who will deposit that amount before the LAO collector. Deposit the enhanced amount. The list of witnesses examined on behalf of the petitioners indicates that no witnesses was examined on behalf of the opposite party special LAO, nor any written statement was filed on behalf of the special LAO. Apparently, as far as contest to the amount, enhanced amount claimed, or the basis thereof, or the basis of determination, has not been disclosed in the judgment. Now, thereafter, next paragraph. Being dissatisfied with the determination of the compensation at rupees 56,41, 905 per acre on the date of notification. The appellants have further challenged by filing the present appeal. The order dated 29/6/2015. Payment of court fee was exempted in this case number 185 of 2013. The matter was then referred to the National Lok Adalat. By 9/12, order dated 9/12/2017. It is observed by the learned judge Lok Adalat that court for the 9/12/17, it is submitted by the learned counsel for the appellate in Lok Adalat. Thereafter, this case number 139 of 2016, a 17 Purvur लिखे हो just 17 Purvur data लिखिए. This case number 3 कितने रखिए 139. This case number 139 of 2016 has been filed for intervention. Judgment appearance lecture, Mr. Niranjan Panda, N. Panda, Niranjan Panda, 1 for the appellants. Mr. Sanjeev Swain, AGA for the respondent. Mr. Sushanta Das, senior counsel, instructed by Mr. P. Das for the intervenants. In view of the issue raised in the intervention application, for the last more than about 9 years, for more than about 8 years, the state IA has been subject matter of adjudication. Both the respondent, Special Land Acquisition Officer, represented Special Land Acquisition, objection file କରିଛନ୍ତି?
No.
The appellants objecting the intervention application. Accordingly, the IE is taken up and disposed of along with the judgment. IE लिखो IE number 139 of 2016. Here, Mr. Das, apart from order 1 rule 10,
Hello.
Rule 5, Chapter 7 of High Court rules.
Section 50,
Sorry, kindly speak to the microphone.
subsection 2 of section 50.
Subsection 2 of section 50.
Yes, ma'am.
The application has been filed under subsection 2 of section 50 of the Land Acquisition Act from 1894. Read with 4.1 R.10 of the Code of Civil Procedure 1908. You can take your seat. You can take your seat. In the said IA, a specific stand has been, specific averment has been made, and it is contended that no notice was issued to either the East Coast Railway, the project proponent, on whose behalf the land was acquired, or the intervener company who has undertaken the liability to pay the compensation amount in respect of the land acquired for the project, by virtue of an agreement or memorandum of understanding with the Ministry of Railways. Though the award has not been challenged separately in any connected IA, LA, Mr. Das, no separate LA has been filed.
No.
But it is also prayed in the IA that in absence of the statutory notice to the railway, East Coast Railway, or the intervener company, the award has to be held as a nullity. In the background facts as noted above, and the proceedings, those have happened before the Miscellaneous, as well as the reference under section 18 that was undertaken. Before the Lord Civil Judge Senior Division, Kamakhya. The contention that East Coast Railway, neither East Coast Railway nor the intending intervener company, was made a party or heard remains unrebutted. Alright. The learned counsel appearing for the appellants. Mr. Ponda was heard at length. Mr. Ponda has left. Yes, something.
Manoj?
Mr. Ponda is not has some difficulty.
Another matter.
Another matter.
So he was called, therefore he has
No,
gone
no.
without disturbing.
No issues. Because it is completed. So
No, he said that I don't want to disturb the court because he's dictating the orders, therefore.
no, that's so nice of him. And nice of you also for informing me that no further disturbances. Only heard at length. Heard at length. As there is a serious opposition on behalf of the appellants to the intervention application. But on the face of the records, it is fairly considered that neither the East Coast Railway nor the intervener company were made parties or heard before the referral court. And as a and obviously there is no reference to any WS written statement or any other response from railway or the intending intervener. In the LA case before the referral court. पर अपन जोटा ऊपर में सबमिशन लेकर करो सबमिशन उड़ा के लिखना मिस्टर पंडा करो तो वो पूरा रिप्रोड्यूस कर दो ठीक है जस्ट खाली इसे नाहांती जो दियो तो फिर टीटे दे सही दियो I refer to his written notes, paragraphs. Right. तो पौधा का कमीशन उड़ा का সেটা কিছু টাইপ করি না ঠিক আছে অধা আছে এটা পুরোটা রিসিভ করবে পুরোটা রিসিভ even notice issued by the LA collector secretary जोटा अच्छी সেটা पे अपन डिस्कशन में अच्छी is contended by Mr. Ponda that notices letter dated so and so was issued to the judgment ita lekhichନ୍ତି Gregory Patra judgment hochi apankara Yes, 2017. Satish Kumar Gupta versus State of Haryana. ସେଟା ବି ଅଛି ଡିକ୍ଟେସନ ଆପଣ ସକାଳେ ଯୋଉଟା ଡିକ୍ଟେସନ ନେଇଥିବେ ସେଟା ପରେ ରଖିବେ ଆପଣ ଯାହା ସକାଳେ କରିଛନ୍ତି ଯୋଉଟା ଏବେ ଟାଇପ କରୁଛନ୍ତି ସେଟା ପୁରାଟା କମ୍ପ୍ଲିଟ କରିବେ ତାପରେ ଏଇଟା ଲେଖା ହେଲା ତାପରେ ଏଇଟା ଲେଖା The lauded AG, Mr. Swai, referring to the judgments in Satish Kumar Gupta, Supra, 2017 4 SCC 760, and Gregory Patrao versus Mangalore Refinery, into bracket 2022 10 SCC 461. अच्छी से डिसीजन गुड़ा का अच्छी स्ट्रिक्टली वहां पर रिप्रोड्यूस सुप्रा लिखते हैं submits that in view of the memorandum of understanding having been subsequently executed between the Ministry of Railways and the special purpose vehicle, that is Hon'Ble-Duguri-Rukinda Railway Limited. They are not necessary or proper party in the proceeding before the LAO or the referral court under section 18 of the LA Act. Yes, Mr. Swai, any other submission?
No, that is.
That is the only submission. But the Lauded AG fairly submits that even the East Coast Railway, the project proponent, was not made a party or heard in any manner in the referral, in the reference. He contends, he further submits if the matter is restored back to the LA collector. Sorry, the referral court, London Civil Justice Senior Division. East Coast Railway should be made a party.
And the MOU signed between the parties can be looked into there. The MOU signed with the present intervener, that will be taken care of that court.
Yes, that is referred.
Yeah,
You have the
okay.
submission is that he is a subsequent.
Once
party,
railway will become a party, so MOU with other parties, that will be taken care of by railway.
The Illinois Senior Counsel for the intervener applicants rely on the decision of the Constitution Bench of the Supreme Court in পি আবাস এবং বিকাশ ইউ ডট পি ডট আবাস AWAS এবং EVAM বিকাশ BIKAS space PARISHAD পরিসর then space V dot Gyan Devi GYANDEVI then colon into bracket 1995 bracket closed 2 SCC 326 colon AIR 1995 SC 724 ଆପଣ ଏଜୁକେସନ ସକାଳେ ଅଛି ତ ଫାଷ୍ଟ ହାଫରେ ନେଇଥିଲେ ପୁରାଟା ଆପଣ ପାରାଗ୍ରାଫ 42 ପଏଣ୍ଟ ସମଥିଙ୍ଗ ପୁରାଟା ଦେଇଛନ୍ତି ରିପ୍ରୋଡ୍ୟୁସ ହେଇଗଲା ତ ରିପ୍ରୋଡକ୍ସନ କରିବେ ସିଧା ଏସିସି ଅନଲାଇନରେ ରିପ୍ରୋଡ୍ୟୁସ କରିବେ Senior counsel refers to paragraphs 48 to 56, 57. And draws attention of the court to the same. Senior counsel relies on the decision of this court rendered by a coordinate bench in Pitambar Sahoo versus Hon'Ble Sukinda Railway Limited. Colon देके लिखिबे 2016 into bracket 2 Roman 2 INR INR dash UT 212 then again colon 2016 into bracket Roman 2 OLR 27. Referring to the decision in Pitambar Sahoo Supra. So that's it is the same Hon'Ble Sukinda company here also.
Same company.
Same company.
Same company.
Referring to the decision in Hon'Ble
Same
Sukinda.
counsel, same MOU.
Okay. No, in fact, I was answering to Mr. Swai's proposition to that only, that since I would not reopen that issue.
Well,
Referring to the said decision in Pitambar Sahoo Supra. Is submitted by the learned senior counsel in response to the submissions of the appellants as well as the contention of the learned AG that after the authoritative determination by this court in Pitambar Sahoo, it remains, it is no more res integra that Hon'Ble Sukinda Railway Company Limited, Railway Limited, a company incorporated under the Companies Act, is a person interested as defined under section U/S.3b of the Act, and appeal filed by the said company under section 54 of the Act or petition under section 52 of the Act 52 the 50 into bracket 2 50 bracket 2 of the Act read with order 1 ruled as 10 of the CPC is maintainable. Please also agreed at the bar that the decision dated 29/4/2016 in Pitambar Sahoo Supra still holds the field. Stop. Sapara, therefore, this court is not required to go into the said issue, as in the elaborate order, the coordinate bench considered the memorandum of understanding entered into between the railway and the petitioner company, the scope and interpretation of various clauses of the said MOU, the scope and interpretation of various clauses of the MOU, all capital. And also the fact remains that Pitambar Sahoo has dealt with the same land acquisition process. That is, the notification for acquisition of land under section 4(1) of the MA Act 1894. Read notification number 26720 dated 07.07.2010. For acquisition of land of the ADS New BG Rail Link for East Coast Railway. You judgment paragraph 3. You are relying on paragraph 3, then paragraph 7. Page nahi.
In that Pitambar's case,
Pitambar.
my lords. Paragraph
3 is the facts, then 7.
Paragraph 10 and 11.
Paragraph 10. The paragraphs of the said judgment as relied on are reproduced here. For the mark condition, green page highlighter. Sorry.
Paragraph 11 has been repeated in the reported judgment twice as the 2 paragraphs.
Oh.
Your lordship can see it from page 10 and again another para.
You are holding Monopatra.
Yes, ma'am.
Monopatra copy like this. Kota certificate bhul achi.
Paragraph 11 at page 10.
Copied outside ये mark कर दिया. Tick mark कर देने भाव. Don't have to underline. Just take out a tick mark. Any lauded counsel waiting for any matter? So one thing I will suggest that this list will be added, taken up tomorrow or day after.
I mean, pardon me, Lord, my matter will be taken up for some other day. Item 11.
Yes, yes. Item 11 you mentioned, I remember.
My lord.
May I please your lordship?
Sir,
Okay.
let me complete, Mr. Sahoo.
Date, my lord.
Page wise call करते हमें जाइए actually page 1 था page 2 भी call करते
Page to item 11, my lord.
पेज
11
1 ने गोटे पैराग्राफ आइटम 6 टा रहगला पेज 1 नो
Date.
आइटम 6
just a second. Item 11 केबे को चाहछन्ती
Sir, next week जेबे नले छुट्टी पर sir.
ए आपनकर 8 तारिख रे असुविधा अछि
छुट्टी पर sir नले आसु छुट्टी पर आसु.
नहीं सर आपनकर लिस्ट न जाउ आपनकर काली रहले
Sir, मोटे affidavit और document देबी.
जहाँ भी अच्छी बट the order has to be passed आपन सकाळे से बुझेली जे without passing an order I will not adjourn the matter आपन जहाँ कहिबे I will record that then I will adjourn.
आज्ञा.
So how is it possible at the time of mentioning I have to pass a order सेटा मु आपन सेतबेले सकाळे भी कहूची so
Okay.
it has to be in the list so that maybe I will take up mention matter first tomorrow that's a different thing. काली आसले हमरा पर दिन ना केबे चाहू
Next week sir.
तो डेट कर दियो
My lord, item number 12, my lord.
12 5
Kali asu aga. So that is regarding regularization.
Petition. Mr. Mahapatra, item 6.
item 6 my lord my appearance is for UP2 but my name has not been reflected
I am here, lordship. I am saying item 6.
Again?
Item 6, I am here, lordship. Item 6, I am here.
Mr. Mahapatra,
Lordship.
OP2 he is appearing.
Yes, lordship.
yes your lord
So when do you want? Mr.
day
Mahapatra.
after tomorrow or Thursday whatever your lordship's convenient
It is a order Mr. Mahapatra, when do you want?
Any day, lordship. Convenient to by honorable court and my friend also. No issues, lordship.
Dates keep now. 8 तारीख रखी थी
Item 9, my lord.
Thank you, lordship.
just a second
आज्ञा.
The interim matter is still, lordship. May kindly continue, lordship.
yes
Item.
whichever is interim order it will continue no difficulty
Grateful,
and
lordship.
my name may be indicated
Item 9, my lord.
7 mentioned
Seven.
serially we are going
Item number 7, Kali asu again tomorrow asu, my lord. Item number 7, my lord.
tomorrow no day after
Tomorrow.
any day after he paribo
Oh, my lord. Yes, my lord. My lord.
order has to be signed and posting has to be
Oh, my lord. Item number 7, day after.
item 7 में की after the government council so fine सात पे 5 item 8 call करना है
Item 8.
Item 5, my lord.
5 yes
Yes, my lord. Item, yes, I am for the appellant, my lord.
yes item 5
Yes, my lord. Item 5, my lord.
Item 5.
yes
My lord.
Mohanty.
Yes. See, the noting is there, request for issue of notice not filed, but I have already filed, my lord.
My lord, I am respondent number 1, my lord.
अपन केबे फाइल करले सुमान
1 तारीख 1/5.
1/5
Yes.
steps to be taken
My lord,
तो एटा अपन तापर नोटिस जीवो
notice you, yeah.
वेट करो तो नोटिस जीवो आफ्टर वेकेशन अपन कंटिन्यू करो एक साथ
Item 9, my lord.
जस्ट अ सेकंड सेकंड मेंशन करछोनी के रेस्पोंडेंट पई की
Respondent by option this respondent number 1.
Respondent number 1, my lord.
अपन को नाटा गयाधर सिंह
Anand Basudev Parad.
उकिल कमला
अपन
SN Pradhan. SN Pradhan.
एसएन प्रधान जी अपन को नाटा कहिबे ना अनंत वासुदेव पराड
नहीं, Anand Basudev Parad, मैं respondent number 1, my lord. SN Pradhan. SN Pradhan.
अपन को ना एसएन प्रधान तो
आगे.
ठीक है are you to think before you leave the court what's your name and then mention yes
Item 9.
then item
9.
serially जाउ छै
Item 9. 9. There is a noting that
on the postal endorsement, no such person return. I will file the requisite in correct address, my lord.
Have you discovered?
Yes, my lord.
Unless you discover, don't file it.
Yes, yes, my lord.
Correct address you have discovered.
तीनटा address थिला, गोटे address जाई परतिला, तापर आ गोटे address जाइतिला, आ गोटे address बर्तन Bangalore address रे पठे देबी. तांगर judgment divorce suit टा एटा गोटे maintenance file करतिला जोटा कि
How much time for requisites?
my lord.
How much time you will take for the requisites?
2 days.
2 working days.
Interim order may be extended.
Requisites. केते तारीख कहउछंती 2/7
Interim order may be extended.
2725
Yes, ma'am.
आपण टे माइक्रोफोन रे कोनांतु कॉल कोनांतु I was interim order to
Yes, interim order.
Yes.
Item 10.
May I please, your lordship?
Item 10.
Item 10.
Yes, please.
Lordship, noting shows that the issue of notice cannot be complete due to some insufficient address.
Yes.
My lordship, 1 week time may be given. We will file the new address.
Have you discovered the new address? First of all, you have to make a submission that as per your instruction, there is an address where you can take notice.
Yes, ma'am.
Unless I record that, there is no point in repeated issuance of notice. ठीक अछि आपनकर 14 रे आसिले चलिबो.
Yes, my lordship.
14th रे you an address and make a submission. I am simply adjourning it, but recording that it has remained unserved.
Yes, my lord.
आपनकर नाटा
Sarmishtha Panda.
power 9.
My lordship.
Power 9 power
No, my lordship. Ellen Patel.
12 रे आसु आपण 12 instruction नियंतु.
Yes, ma'am.
Whenever you are making a submission that you will take fresh notice, I have to record that yes, you will take it in the fresh address or you have discovered an address. Like you heard Mr. Biswal submitting that. I have an address. Yes, next call करो. 11 वाला.
May I please, your lordship?
Item 12.
Page 4, item 12.
12 tomorrow, my lord. It is regularization matter. Your lordship had is extensive.
7 रे आसु. 7 रे difficulty अछि आपण.
Na
7 रे day after.
7 asu.
Who is for the petitioner?
Mr. Rautrai was submitting, my lord.
Let us see on that date. 7 रे आसु. Yes, next.
13.
I have to go to the opposite party, lordship. 1, 2, 3.
So let it be simply adjourned. In absence
Yes,
of the
sir.
petitioner, it cannot be taken up. 7 5.
14.
14, may I please, your lord?
Yes, please.
I'm on behalf of Miss S. Patnaik. She, due to personal difficulty, she is out of town. So kindly adjourn to next week.
Petitioner अचंती की petitioner तो नाहंती ना. You are for the petitioner.
I'm for the opposite party.
Exactly. So simply adjourn 7 5. 7 5 जज छोड़ो आप जब डेट रे डिफिकल्टी अछि जल्दी कोन 7 5 ना को दिन देबे
7 5.
चलिबो. Because I do not know आपण 7 5 रे केते मैटर लिस्ट करछन.
15.
Yes, item 14 bills.
आपण तो petitioner पई.
Yes, my lord. A counter not filed.
से टाइम मागुचंदी. केबे को रखिबे. Kindly respond. आपण को petitioner आसले.
Just
RK Behera,
opening.
RC Pradhan. You are
last
Pradhan.
last chance से दिया जाओ.
You are RC Pradhan.
Yes, my lord.
ठीक अछि एटा विथ ऑब्जेक्शन एटा आपण डेट करे पड़े आफ्टर वेकेशन ऐसे टाइम मागले 4 7 है मिस्टर प्रधान
Charge.
आपण को नाटा कहलेनी व्हाट्स योर नेम
Shivam Misra, sir.
शिवम
Shivam.
ऑन बिहाफ ऑफ
On behalf of Miss S. Patnaik, Somalin Patnaik.
ते आपण 2018 मैटर ऑब्जेक्ट काउंटर फाइल करनांती
Sir, counter file ही जाइए sir. मो पाखरे कॉपी अछि मो एबे दे.
Copy note, sir.
हां कॉपी एबे गोटे देई दउ छी.
मिस्टर प्रधान आई एम रिकॉर्डिंग दैट यू हैव
Billers.
Yes, next.
15.
15 ଟା ଆପଣ simply adjourn କରିଦିଅନ୍ତୁ। ମୁଁ ଡେଟ୍ କରିବି।
So 1 week যদি
No.
9/5. Yes, next.
16.
ଡେଟ୍ କରନ୍ତୁ।
No.
ତାପରେ
17.
ଡେଟ୍
No.
କରିଦିଅନ୍ତୁ। ଆଜ୍ଞା?
No. 5.
Yes, next.
18.
18 to 20. Anyone
20
present?
mile, 20
আচ্ছা,
mile.
তাহলে 18 ডেট করନ୍ତୁ।
No. 5.
19?
19.
Number 19, I'm for the petitioner.
Yes, please.
I'm filing written note of argument matter.
No, before the matter is heard, so there's no point in filing. Let us hear the matter.
Matter.
You base
Maybe
your
take it
submissions on the basis of written notes.
Any day after vacation matter.
Opposite party ki option
I am for the opposite party number 1, my lord.
Acha.
I have already filed my written notes of submission.
But since the
Yes,
it will be hard for the first
before
time
this honorable court. Yes, yes. I am ready, my lord. Then let me please.
Miss 19 Suman Modi. Opposite
Any date
party.
will be fixed, my lord.
Date after vacation matter.
Date करନ୍ତୁ sir.
7.
7 को।
Interim order to continue.
Copy টা মত ওটা দিয়ে দিও।
Copy the date.
Mr. Mahari, interim order to continue.
My lord, my lord.
Yes. Call करନ୍ତୁ।
Item 20.
While 20 mile, your lordship specifically directed the state to file the counter affidavit. The counter affidavit has not yet been filed. Let it be listed after
Item 20
vacation.
which for the state.
After vacation.
Counter file any को।
Counter, I will
Counter
take
file.
care of that.
So why you are there?
Actually, it has given to Mr. Mahanti because he is the brother, so he will not fund that.
नहीं ठीक है जी Mr. Sanjeev sir.
Yes. Interim order may continue, my lord.
4.
4 ही 7 है।
Interim order may
Interim order to continue.
continue.
Yes.
21.
So Mukherjee.
He was there. He was
Yes, Mr. Mukherjee was there.
Yes, Mr. Mukherjee was there. He was requesting me to after vacation.
After vacation.
7.
7. Yes.
22.
My lord, I am opposite party in this case.
Yes. Who is there for the petitioner? So let it be simply adjourned. Some other date may reach, but a date कर दियो तो।
May in this week.
No. 5.
Yes, Mr. Shodangi.
Yes, my lord. Deep level.
No 5. Simply adjourn.
Deep level.
23. 24.
Mr. Mukherjee, your matter 7.
21.
Yes, Mr. Swai mentioned for you. Since you are there, so I have noted your presence and 7.
7 ঠিক আছে
Interim order is
সেদিন
there.
সেদিন অবজেক্ট করছিল I will do this matter yes I came.
So today he is not there. He is simply mentioning on your behalf. So one of his colleagues would be there.
Grateful.
So interim order is there.
Yes.
Is Dakon 23 Dakon?
23. No. 5.
No 5.
24. No.
Yes.
25.
Yes. Next time Dakon quick करो.
26.
May I please?
26 sir. So it is not reached today. So either you want it after vacation or before vacation, that's your choice.
Interim order may continue. Let it come before vacation.
Yes sir.
Item 22, my lord.
Again?
Item 22.
22 no 5 रखछंती. Any other date you want?
Put it after vacation.
Mr. Sahoo is there.
My lord, the matter has been stayed. Lower court matter has been stayed, and it has been adjourned multiple times.
There are so many matters stayed. How can
My
you
lord,
take
he
it?
has not served the copy of the IML.
My lord, the matter may be heard finally. So let it be on 9th.
Das, kindly listen. Today the matter is not reached.
No, he's content.
सुनो तो sir. It is posted to 9/5.
My name.
Yes, 9/5 ଆପଣ ଯାହା କହିବା କଥା
His conduct. He has
microphone ରେ କହିଲେ ଯେ ଶୁଣ
without service.
My lord, if I file, the counter people will say, you first serve copy. He has
My lord,
filed the IA for last 3 months.
Even he has filed an amendment petition without serving me. I only pray the matter may be hard final.
Whenever there is a matter between husband and wife, so it is not necessary that the lawyers should also raise disputes like this.
He is not paying a single pie.
Both of you now raise dispute that the copy has.
The mastermind, he is the husband is not paying a single pie since 3 years.
ସେ ଅର୍ଡର ଆପଣ କୋଉ କପିଟା ଚାହୁଁଛନ୍ତି ଯଦି ଦେବେ ତାହେଲେ କଣ ଆର୍ଜନ ହବ ନା କଣ କୋଉ କପି ସେ ଦେଇନାହାନ୍ତି ଆପଣ
ମତେ amendment petition ର କପି ବି ଦେଇନାହାନ୍ତି ଆଜି ଗୋଟେ ମୁଁ vacation stay ପାଇଁ ଫାଇଲ କରିଛି my lord the matter may be fixed on 9th let it be hard finally my lord I only
Mr. Shivsankar Mahanti being in between Kotak.
My lord, he is not coming to the court. Well,
I have
to whom I will serve. Today I will serve. Let him come.
On the last occasion I was there in the court he was from Sambalpur.
You take, this is the copy. You take.
Mr. Das was not feeling well.
My lord, let it be served to let it be served to one.
ଯଦି 9 ତାରିଖ ସୁଦ୍ଧା କପି ସର୍ଭ ହେଇ ପାରିବନି ଆପଣ 12 ରେ ରଖୁଛି ହେଲା 12 ରେ ଆପଣ କପି ଟେ ଦୟା କରି ସର୍ଭ କରନ୍ତୁ you request Mr. Mahanti to help you.
He can take on behalf of me, my lord.
Your team kindly see, he is not coming to court regularly.
The amendment
for last 4 months or 5 months.
So late.
I am always here, my lord.
Say Mr. Mahanti will accept on his behalf.
Yes.
I am always
here.
here.
ଆପଣ amendment ଦେଇନାହାନ୍ତି ସେ କହୁଛନ୍ତି.
Lawyer ଭଳିଆ କହିଲେ ମୁଁ କିଛି କହୁନି.
Pattern to be mentioned.
Mr. Sarangi, kindly ensure that a copy is served.
Yes, my lord.
Mr. Mahanti, you take more of Mr. Das.
Yes, I serve.
And request his clerk to take the point.
My lord.
My item was 24. My
Just a second. Yes, Mr. Mahanti.
24.
24.
No, ପାଞ୍ଚ ଦେଇଛି।
22ଟା 12-5 कर दियो ହେଲା।
You lordship.
12-5 22ଟା 12-5 है। Then Shivsankar Mahanti
24.
केबे चाहुଛନ୍ତି ଆପଣ?
Lordship, as per convenience of the court.
No, convenience nahi because since all of you are waiting, so I am taking up the. Otherwise, I would not have taken up also. 12-5 9-5 any convenient date.
No, तो नहीं again 12-5 था।
12-5 ठीक।
Pattern to be mentioning
Yes,
your lordship's item 8. I was not there. So
just a second. I'll come back to it.
The entry matter shall continue in that case.
Item 27.
Entry matter ଅଛି।
Again.
ଟିକେ ରୁହ। I also. Then 26 रखले ना।
25, 26.
केबे रखछन?
9-5.
9-5. Yes, next.
27. 28.
28 lordship, I am here for the petition lordship.
27 date kale nahi.
9-5.
28.
28. Yes, lordship, I am here lordship.
Yes.
I am for the petition in this case.
Who is there for the other side?
One Aditya Mahapatra.
So you suggested date can be.
Let's make call this after vacation.
So he's not there. I can't. After notice matters, I will not.
As your lordship then.
Date करंदो at least.
12-5.
12-5.
12-5.
Yes.
The entry matter is a kind.
Entry matter thile continue. Nothing to worry. Simple adjournment. No order is passed. It will not be modified. I follow that Odisha High Court earlier decision. Allow us that.
As your lordship. No issues. Okay.
29.
Adjourn take कर देबे?
9-5.
Yes.
30. 0-5.
Mr. Uma Charan Mishra, I think he has passed away. Uma Mishra has passed away.
Passed out.
I don't know. I heard that.
No, he was there. He was teaching students of OJ student पढ़ाता ना।
I'm sorry. Uma Charan. No, he's Ponda.
Uma Pondas.
Sorry, sir.
13-5.
कर दियो 13-5.
31. 12-5.
12-5 ठीक है।
32.
32 कॉल ହେଇଥିଲା ସକାଳେ ମେନସନ କରିଥିଲି। ହେଇଛି ସେଟା ଏଣ୍ଟ୍ରି ମର୍ଡର ହେଇକି 1 1 7 25 କି ଯାଇଛି। ଆପଣ ନୋଟ କରି ନଥିବେ ଦେଖନ୍ତୁ। 33.
33, my lord, I am for the petitioner. Notice here is sufficient.
My lord, I am appearing for the wife. My petition for transfer my lord, the CP from Sambalpur to Jagatsinghpur.
34, Mr. Mahapatra, you are there.
33, my lord. I am 33.
33, you are for the other side.
No, I am for the petitioner because my
this is
name is in
34.
second.
So 33.
Second.
12, Mr. Mahapatra.
34.
34, you are appearing for the.
My lord, I am appearing for husband.
When did you file your Wakalatnama?
Sir?
Wakalatnama have you filed?
Yes, Wakalatnama file notice has already been issued. To
Kepe file kale.
sir,
What Wakalatnama ଦେଇଛନ୍ତି କେବେ ଦେଲେ?
last week, sir, last week. 3/5. 3/5.
What order का date कर दियो?
Sir, sir.
So the Wakalatnama will be taken on record, list on 12/5.
12/5. Sir.
Next, please.
35.
Date कर दियो.
9/5.
Next one.
36.
Date कर दियो.
0/5. 37.
On behalf of Shivan Shankar, my lord.
Yes.
On behalf of Shivan Shankar Pradhan, my lord, I am for the appellant. The matter may be taken.
It's the other side is there, you take a date. The order has to be passed. Just understand. There will be simple adjournment. The next date, whatever you say, it will be done.
In last 2-3 officers, my lord, other side has not appeared.
Could be, sir. It is taken up out of turn on mention. Called by the court master out of turn.
13/5.
13/5.
38. 9/5.
9/5.
39.
Yes, date करो.
12/5.
12/5. ठीक है.
40.
Date कर दियो.
13/5.
Your Lordship's item number 8 is only to get notice again. Your Lordship's already, it has been adjourned to 16th of October 2023. I have been already submitted the requisite along with the postal fee, but till time.
It delayed.
Yes, Your Lordship's.
It was filed on 10/10 beyond the date granted by the court.
Yes, Your Lordship's.
केबे थिला केबे सुधा फाइल करिया कथा.
Your Lordships, actually, they told me that I have already filed the requisite, but after 2 days, Your Lordships, they told me that one document has been absent in the list of requisite.
Complete requisite not thila.
Yes, yes, I have filed on 15th of October 2023. Your Lordships, yes, Your Lordships. Your Lordships, already 2 times notice has been went there, but unfortunately the.
Modify. Cannot modify the
Yes,
order
yes,
directing
yes,
you to
yes.
file.
Yes, only notice to.
In the coordinate bench has already directed and you have complied. Notice दिवो केबे date करो.
8/4.
In both matters.
Yes, Your Lordship. Same person, Your Lordship.
So list after SR 8/7.
Yes, Your Lordships. And Your Lordships, in both cases, there is the interim order. It should be continue.
Yes. So Pradhan.
Obliged, Your Lordship.
Lordship, pardon your Lordship, item 17 on behalf of Madam Panda, your Lordship.
17 9/5.
9/5.
Obliged. After vacation, your Lordship. That item 17, can it be after vacation due to some personal reason?
No, in absence of the other side, when both of you are present requesting for a date, I have adjourned every matter. No difficulty. Even you are, exempted from appearing also. But in absence, don't preempt them. That doesn't look nice also. So on 9/5, it is possible that it may reach, since hearing matters are being taken up. That is how this has. Tomorrow also there is a hearing day. So, but obviously, if it is not reached before vacation, it will go beyond vacation. That is the other way of looking at it.
I was.
Yes, sir. Yes, please.
Another court, sorry.
Yes, absolutely, absolutely. You are very well represented by Mr. Swine. Mr. Swine submitted on your behalf. Yes. I was just recording things. I was looking for you since I was recording your submissions. That I wanted to record in your presence. Like in the morning, whatever you have submitted, I have reflected in the order sheet. So that I was looking for you, that in your presence, I will dictate that.
Only one more line.
Please, please.
Only one more line.
Again, kuhantu.
Decretal dues has been deposited by the East Coast Railway Requiring Authority.
You can ask Mr. Swine, Mr. Das. I have mentioned the amount also. I have mentioned the amount also, and you have received with protest. So I think if you are, I mean, the doesn't have the jurisdiction to overturn that also.
What I beg to submit.
So beyond that, sorry, no, is it your apprehension that 26 lakhs you had, accepted, some money you have accepted, whatever amount, that is being questioned by them or any of the parties? No, I don't think that's their contention also. When they do not challenge, they are worried about, they are only worried about the enhancement. And as I told you, they may have to pay the enhancement. Once it's a live litigation, still there is a cause of action since you have been fighting by reference 18, then it has come in LA. So time has passed, about 15 years has passed.
I will be much more happy that because I participated in bringing the honorable court's notice to the relevant.
The other part is that
only my apprehension.
If the written statement would have been there on their behalf or anyone's behalf, at least the LA would have been adjudicated. That is the other difficulty. But as far as they depositing and you collecting the money, that is not being questioned by anyone.
But my lord will appreciate. It is originally land I was acquired in 2010.
Correct.
Now we are in 2025. Remitting back and for decision again for with regard to the further enhancement, because 45 was awarded by LO, it has been enhanced to 56 somewhat. It has been satisfied, LO has already paid. Now we have come up from 56 to 9, because my side land is 9. It is the fight between 56 to 9. Now, after remand, suppose some time will be taken and the client will appreciate that because land is very small amount of land. For this small amount of land, now again going for fight, again for appeal, again for, so all these things. So that is why I beg apology, my lord, that to take instruction from the client, if he wants to close it here or he wants to proceed. Only that much.
Mr. Panda, somebody fighting for his right, how the court will say that let it be closed. Just imagine the other day I was hearing a matter where 65 lakhs of compensation. A lady comes, she says that I am the sole surviving person, legal heir. The amount is taken by somebody else. The case is that he is no one. He's son of somebody else, but somehow the land acquisition officer has paid him. The lady comes to High Court. She's illiterate. She says that I am the sole surviving legal heir, being the sister. The person is issueless and dies intestate. The land losing person, and interesting person who claims that he's the son, his father has also land there. So in this kind of scenario, whether these persons are entitled for enhanced amount, can this foreclose that? No. It should not. You may say that, but you should have thought that when in 2014 you approached or in 2011 you approached them for reference.
नहीं, अब
So there you should have thought that. Now you see, even in that particular matter in Haridaspur rely on Sukinda. This is a Sukinda case. Haridaspur matter, at least somebody has made a party. You heard Mr. Swine. Mr. Swine says East Coast Railway could have been made the party.
Railway rather I agreed to the.
So fair enough. If they don't challenge, they don't challenge.
Now railway paid in 2000.
But they may forgo their claim before the referral court. That's another thing. But how this court at this stage can preclude that?
But the claimant's appeal my lord is dealing.
Correct.
And claimant's appeal in 2014, railway satisfied the decree in 2015.
Correct.
They came up, company came up here in 2016. Now we are in 25.
Correct.
So with this background, whether it will be prudent for my client to proceed further or to close it here.
Mr. Ponda, how can the appellate court in High Court will foreclose that? That they may decide and they may not proceed before the referral court.
Commission,
No, how can it?
No, because
ଆପଣ 11 ବର୍ଷ କାଳ ୱିଡ୍ର କଲେଣି ଜଜମେଣ୍ଟ ଡକା ହେଲା ପରେ ମୁଁ ୱିଡ୍ର କରିଦେବି ଏଇଥିରେ କେମିତି ହବ that is you are saying that you want to withdraw the appeal.
Appeal merit is not the question. Question is intervention. Whether intervention will be allowed or not. And if thereafter we will party in the appeal, then we will have a choice.
Much water has flown to withdraw the appeal now.
My lord,
ଆପଣ withdraw କରିବା କଥା so that then you should have withdrawn in 2014. 25 ରେ ଆପଣ 14 ରେ appeal କୁ withdraw କରୁଛନ୍ତି. So
I just went with the kind notice of
Mr. Ponda, you never know. As I told you that they may have to pay more amount, I cannot say. But the issue is regarding questioning the determination, the procedure adopted in determining. That's the difficulty.
Now, after that determination was made, it was satisfied by the requiring authority. Now, for further enhancement, when I have come, that is why I make a submission for my lord.
Para 11 and 12, Mr. Das.
Yes.
You have marked in this blow letter.
Yes.
Para 11. Monopatra print. Para 12, this is actually highlighted post. Suppose now even Mr. Ponda, maybe you might be thinking that since after Pitambar Sahoo, this will be the second judgment. But
Pitambar Sahoo case
exactly. So that is how after Pitambar Sahoo, it is for you to decide. It's not for
after Pitambar Sahoo, yes, read code decide. Read code has said. Read code mu deisla page bar re achi. Page bar re read petition le. She likely considering the submission made, we find that the beneficiary of the land acquisition has no locus standi to intervene in the present writ petition, where a prayer has been made by the petitioner only for direction to the special land acquisition officer and opposite party number 3 to pay the awarded compensation amount to them. There, this court division bench has held this.
Mr. Ponda, it is so simple. You opted not to implicate anyone in the before the land acquisition referral court. I asked Mr. Swine, if you want to pay, you pay. He doesn't take that responsibility. The direction is to the LAO to pay the amount. And there is no discussion who will pay, who will deposit, what is the rate, nothing. LAO will calculate and pay. Yes.
If they show like they may approach the law.
That is noted. This is a better order. In that way, this is a better order, remanding everything to the lower court. Upon enhancement, they can't escape now. Can they escape the judicial process now? They cannot.
That is not the my client. Suppose now ultimately do not proceed with the appeal. That is the reason that I draw my lord's attention.
No, no.
For that, I just seek
No.
some time to have a,
No. Not after 14 years. You see, then the whole process farcical and a matter of joke. You pursue a matter for 15 years, suddenly say that we will not prosecute. After the arguments and judgment is dictated, you take that plea. It's not.
my lord. I have all put all my cards before my lord.
No, this is not a card. This is not a, this is hitting much below the belt.
Yes.
That you should avoid.
My lord.
Then you should have informed Mr. Das, Mr. Swain that I will withdraw. What is this? After the hearing is over, you are hard for more than 1.5 hours. You say that I will withdraw.
সেটা কইনি খালি ইনস্ট্রাকশন পাই কইতে যদি my lord
This is not the way to proceed, Mr. Ponda.
my lord.
Your submissions are well recorded. You must understand that also. In view of the above discussion, the petition seeking leave to appeal is allowed. Leave to appeal is granted. Allowed and leave granted. The petitioners shall be heard in the appeal. Then LA 33 of 2014. The LA has been kept pending for the last 11 years. As after issuance of notice, application for intervention has been filed, which has been allowed today by the order, above order. And the intervention application was contested all through, without delving into the merits of the appeal. I had ordered counsel for the appellant, for the respondent, and Mr. Das, the learned senior counsel, for the interveners. Again, appeal টা তো রিপিট হচ্ছে আপন যোটা প্রথমରୁ নেইଥିଲେ ডিক্টেশন দুইটা বেলে পড়ি পারিবে না দল কইবে যে আসলে ডিক্টেট করি সেম সেটা সেম again after absolutely पूजा कंटिन्यू करोगे पूरा सेशन में पढ़ाओगे তাহলে বহুত ইরিটেশন ଆପଣ ସେଟା ସରିଲା ଆପଣଙ୍କ ଆপিଲେଟଙ୍କ ସବମିଶନ ମିଷ୍ଟର ପଣ୍ଡାଙ୍କର ସରିଲା ପରେ ସବୁ ଯାକ ତାପରେ ଏବେ ଲେଖନ୍ତୁ ଇନସର୍ଟ କରିବେ ତାପରେ ଲେଖା after Mr. Ponda's submissions or appellant submissions. तो लड़े दीजिए लड़े दीजिए सबमिशन भी अच्छी तापर ऐड करिए लड़े दीजिए फर्दर सबमिट्स दैट the present respondent, that is special LAO, has his role to the extent that the Land Acquisition Act provides is an authority under the statute which undertakes the process of acquisition. At best, they can facilitate deposit and dispersal of such compensation as prescribed by the statute and also awarded by the referral court. The enhanced amount has to be deposited with the authority to be disbursed to the appellant claimants. The Learned Senior Counsel appearing for the intervention permits that as far as the prayer for enhancement is concerned, the order passed by the referral court shows that the contentions of the project proponent railway or the special purpose vehicle which entered into MOU could not be considered as they were not met parties. After Pitambar Sahoo Supra, the SPV is a person interested on the section 3 into bracket small b of the LA Act of 1994. The referral court has to hear the railway and oblique or the SPV for arriving at a decision whether to enhance the award or not. The impugned award dated so and so in LA number LA miscase मध्ये in LA miscase number 126 of 2013. Decided by the current civil judge, senior division Kamakhya Nagar, is restored to file for adjudication. The parties in the present case, that is the intervener, shall appear before the Learned Court of Jurisdiction in the said LA, case number 126 of 2013. That is Civil Judge Senior Division Kamakhya Nagar or any other court that may have been assigned in the meantime. The court shall act upon production of the website copy of this order. The intervener shall file application for impletion of necessary party before the Learned Court. That would be in season of the matter. The Learned Court shall also issue notice to the present appellants. The appellants can appear through their Learned Counsel. The date agree करना. Only problem is that, like in Jajpur, now it is bifurcated to Jajpur Road and Chandipur.
Here it is not bifurcated.
Still there, Kamakena.
Still there. And even your lordship may see that while remitting the matter to a court below, Order 41 also provides that the appellate court can fix up a date for appearance of the parties.
But unless and yes, yes.
I agree, my lord. Your lordship fix up a date.
Yes, yes, you agree for a date.
Your lordship can direct also.
Order 41, the Lord Senior Counsel, Mr. Das refers to. এটা দিয়ে দিন। কাটিয়ে দিন।
Rule.
Rule order 41 R dot 26 dash capital A to submit that date may be fixed before the Lord referral court. Exercising the power under rule order 41, rule 23 dash capital A. The matter is remanded to the learned court, referral court, wherein it shall afford opportunity to the interveners as well as the and oblique or the railways to file their written statement regarding enhancement of the award. Mr. Ponda, learned counsel for the appellant submits that. Any instruction, Mr. Das? Mr. Das, what amount was deposited and who has received any idea? Mr. Ponda is not saying that.
My lord, amount that was determined by the land acquisition collector was paid.
Correct.
They received it without protest.
With protest, they have said.
With protest. Matter was then referred.
But thereafter, any amount has been deposited, that he's saying.
That they have not indicated a word about
I
it
say
anywhere.
specifically decretal dues that has been determined by the reference court, the railway by the letter in 2015.
Where?
I have said I have given the date also.
Upon the
That the
appeal
state
date,
government
only
says LO has paid, and I have said it a particular date. I have also said.
Apanakara, when I was referring to your LA, I could not get that.
29/6/15 the core railway.
Sir, where you have stated that in the LA, where I will get it from your readings, where I get it. I
have written in note of submission.
Note
page
submission.
4.
How can I?
Because in 2015 they have paid. In 2014 I come in appeal. 2015 railway deposited before the LO railway disbursed, and 2016 now he comes. Now my lord is deciding the petition in 2016 petition. In the meantime, before they came up,
Mr. Ponda, can you please hear me? Have you filed an affidavit on oath stating that?
I will file an affidavit.
No, not today. You have taken 9 years to realize that affidavit has to be filed.
Not only oral submission, it is a written submission I have made also.
The written submission by the lawyer doesn't bind show me a provision in CPC. Show me a provision in PPC or CPC or High Court rule or Land Acquisition Act, where the written submission of a lawyer will bind the parties.
My lord,
because you see,
my lord can also the state
that is in your interest.
The state lawyer can also say if it has been paid or not.
You are attributing it to railways. I will ask.
State lawyer will say.
My railway is the acquiring authority, and the state council can also say if it is paid or not.
State council is not appearing for that is the difficulty, and you do not file affidavit so that at least they can respond to that.
Even if it is paid also,
by tomorrow I can file it.
Can nothing.
By tomorrow I can file that.
The merit.
To submit that the decretal dues has been deposited
on paid to the claimant on 3/15 during pendency of the appeal.
Sir, which dues, sir? Once.
By tomorrow I will file an affidavit.
Following the question actually. The awarded amount, they say it has been paid and you have received. So that is not disputed. Wait.
The LO's awarded amount has been paid, and the court's awarded amount has also been paid. Now I have come up with further enhancement.
Date on
29/15.
It is submitted by the learned counsel, Mr. Ponda, that the amounts as directed in the
29/15 railway disbursement.
Mr. Ponda, you are not filing affidavit. You are going on a commentary.
Sorry, I do not want to annoy my lord.
No, I am not annoyed.
Sir,
I have been requesting you, if have you brought in on record that you are insisting that no, I have not brought it on record. I do not file affidavit, but I have to record that, so I am recording that. Upon 4/7/14 has been deposited by railways on kete date authore kahile
29/15.
29/15.
The submission by
counsel appearing for the intervener disputes the same, that since the said fact is not on record in the pleadings or any affidavit, he has not been able to obtain any instruction in response to the same. However, it goes without saying that if the said amount has been deposited, the necessary legal consequences shall follow. The Learned Court of Civil Justice Senior Division shall do the needful in accordance with law. Mr. Ponda, do you think that they will oppose if it has been deposited? Why they will oppose? But the problem is there are 100 cases in High Court. In one case, they deposit the decretal due. In 99 cases, they do not deposit. So they don't have a choice also. This is the difficulty in when there are several cases, batch of cases, everywhere there is enhancement. You
No,
should
once-
not that on the date you find, on that next date, when you get that information that they have deposited, you should have brought that on record. I have been asking Mr. Swami that who is to satisfy the decree. Mr. Das, you also. You are only saying that railway has already satisfied the decree.
This also I have given in 2000.
The satisfaction of the decree, my lord, that may be. that
This
Suppose somebody has been dispossessed by virtue of a decree, which is subject matter of the appeal, and ultimately the appeal is allowed, then what will happen?
Compensation
Restitution.
should take a lenient view.
And in case of compensation also, my lord, what has been held to be a nullity, if you have derived the benefit,
But unless if you see,
legal consequence will follow.
the argument he is making
Let us
that he is depositing
Mr.
before the
Pandya,
railway,
Mr.
That is
Pandya,
true.
He is not there. He is not saying that. He is not opposing you.
then how railway could deposit?
He is
Far from railway, but
he has not
you are
deposited, he is saying,
financing.
Railway
So
deposit.
that is why you have said you have no locus. That is the
Whether the decree has been satisfied or not, that the court will decide. I am not deciding. Accordance with law. The parties shall appear before the court on. So calendar টা কোথায় আছে? On 1st of July.
Yes.
On 1st of July 2025. The Lorette Court shall fix a date for appearance for further hearing of the matter. The matter shall proceed on each date without granting any unnecessary adjournments. It is also directed that the parties, that is the appellants, the interveners, the SPB and railway shall cooperate in the proceedings in arriving at a early disposal. It is further clarified that no part of this judgment and order remanding the matter for adjudication regarding enhancement shall be treated to the expression of any opinion on the merits of the respective contentions of the parties, claims and contentions of the parties. Disposed of accordingly.
On it.
Become of submission. Is there any interim order?
No, my lord.
Mr. Ponda?
No interim order.
No interim order. It is
So
for
then-
further enhancement. That is why I have come.
Then Mr. Ponda, kindly listen. There is no interim order of staying the decree. You would have received the amount also.
There is no interim order. It is my appeal that I have come.
Exactly.
No, I have not taken any interim order.
So if you have taken 26,000 without any objection, you would have received 50,000, sorry, 26 lakhs na consider.
56 point.
Whatever. So
Correct,
you would have-
correct.
You would have received that. So you have to obtain this. I think you are not very correct. When there is no stay order, which I don't think people are that innocent that in absence of a stay, they will not receive the amount.
Wait a minute. State has received from railway. So that is my submission that I have come up for further enhancement.
You have received, you have stated in your petition whatever was awarded. There is no stay order as far as the this referral
Stay-
order is concerned.
It was not for required for me to obtain any interim order because
Disposed of.
whether appeal will be allowed or rejected, that is a different thing. But with regard to there is absolutely no cause of action for any obtaining any interim order. No requirement even was that.
That is the question to you, that you are challenging a order favoring you. You will not get a stay order. So the decretal amount, why you have not received? Because you are saying that Mr. Swine's client has not paid it.
No, what is saying that he has filed appeal.
One case, hundreds of cases are there where the railway has already paid.
Just
Not only in this case.
Our civil court, he has challenged, saying that 56,000 or 60 lakhs, that is not sufficient. But during pendency of the appeal, the railway department deposited the amount before the land action officer.
Recorded.
Yes, land action officer paid deposited in the civil court, and from civil court he has received the entire amount.
I understand.
Yes.
So that is the question,
Yes.
that if he could, whether he has challenged the amount determined by the LAO or not. He has challenged?
Both.
He challenged before the civil judge senior division.
Yes.
Challenging that amount, he received the amount with protest.
Yes.
Now there is a civil court decree in his favor enhancing that amount. The amount is deposited.
Yes.
So my question to him is very specific. Why and how you have not received that enhanced amount which is deposited? Because there is no stay order. Whenever there is a stay of decree for enhancing the amount, then obviously he cannot. No one has challenged. He has challenged for enhancement.
Yes.
You see, it is like this. He was awarded 10 rupees.
Yes.
He received 10 rupees, challenged it. Now he is awarded 20 rupees.
Yes.
Further 10 he has to receive. He says 10 rupees has been deposited by.
No. 10 rupees for 20 rupees he has received.
No, then you have not. Then you have not followed his submission.
10 rupees he has received from land
Correct,
action
Mr.
officer.
Swine. He says 10 rupees has been already deposited by railways. That is his submission, and I have recorded the date also.
10 rupees are received from the land action officer himself.
No.
Then 20 rupees from the civil court.
Very specific. Enhanced amount has been deposited. He says that I have stated in the written note. I have dictated in the order also. He says the enhanced amount has been deposited by the railways
Before the LAO.
before the LAO. Interestingly, 10 rupees deposited before LAO he has received. Enhancement of 10 rupees, he says I have not received.
No, he has received.
No, I have received. Enhanced the amount, decreed I have received. Awarded amount by the LAO I have received.
Mr. Ponda, since you are changing tracks always, in your written note, you have not said that.
Yes, that I have said.
You kindly find out.
That I have said, my lord.
Kindly find out.
My lord, that I have said.
Anyway, that is.
I have said.
Mr. Ponda, that is not.
My lord, I have said.
Who parare kahile je apna?
Para 4 re. Para 4 re kahiche. Para 4 page 4. The East Coast Railway also requested the special LAO for payment of decretal dues by its letter dated on 3/15, and accordingly the decretal dues was paid. So I have said, when the request.
Civil court order has already been complied with, and he has already received that. He wants again further.
Correct. So that he was not following. He has been say joda kahile. In fact, you can verify that it was deposited by railways. He now says that he received on 29/6. He doesn't know when it was deposited. Date ta pai joti ache chiti pado. No. No, it is. See that, Mr. Ponda, you read it slowly. It is not there. So I cannot. There is no affidavit. Just read it slowly. The East Coast, page 4. The East Coast Railway also requested.
Let him take the instruction also. If why
I will entangle? He has no business here. You must understand that the state government is not representing railway. The East Coast Railway requested the special LAO for payment of the decretal dues with its letter dated. You are reading that deposited.
That I have what I have said, I read it again.
You have not indicated. So Mr. Das is correct. You have not mentioned. that it is deposited by railway.
My lord, the equal railway also
Slowly ଟିକେ
requested the
ପଢନ୍ତୁ,
LAO.
ବହୁତ ବଡ ପାର୍ଟି କରିଦଉଛନ୍ତି ଟିକେ ଆପଣ slowly ପଢନ୍ତୁ।
Sorry for that, my lord.
Sir, କାହିଁକି ଆପଣ slowly ନା
On the other two matters, if I am allowed to, because I have not gone through that and I have not.
same matter.
Same identical.
My lord,
Mr. Ponda, I am really surprised that 14-year-old matter, you are arguing it repeatedly. Still today, you are not sure that who deposited and when the matter was taken, or the money was, received by you. Okay, that is not the way to argue, and that is appeals.
Man, ମୁଁ ଆଜି ଏତେ ଗାଳି ଖାଇଲାଣି ଯେ ଆଉ ବ୍ୟସ୍ତ ଲାଗିଲାଣି।
Not that. This is a serious courtroom conversation. Whatever you take, submit, it is taken seriously, noted by me and also your colleagues. Thank you.
For other two items, for some other day, my lord, I am highly obliged.
Same judgment, same thing. That's it.
এটা ମୁଁ ବିଲକୁଲ ଫାଇଲ ଦେଖିନି କି ଖୋଲିନି। Honestly say.
They are simply identical.
ଆଉ ଗୋଟେ ଜଣ ଆସୁ। ଏ ତ already ଏଟା covered ହେଇଯିବ ଏଟା ଖାଲି covered ବୋଲି କହିଲେ ସରିଯିବ।
One day you should feel happy that I am yet to see in my 30 years of experience that one day is attributed to a 14-year-old appeal.
But other two cases
that much you should be satisfied. You may be unhappy. You may be unhappy with the judge or the effort. You may say that the judge doesn't understand. That is one way. But at least
if my is satisfied, we have no objection.
A 14-year-old appeal has been disposed of. That's it. Thank you.
Obliged.
So now